Acquitted on benefit of doubt.
Right. May I please, Your Lordship?
Hmm.
Lordship, with consent of the other side, I beg to mention item number 20, Lordship. 20. Lordship, in this case, petitioner had already expired. Lordship, also, we need some time to file appropriate petition.
Learned counsel, Mr.
H does.
H does with the consent of the other side has paid for adjournment. With the matter after Puja vacation. Okay.
May it please your lordship, I beg to mention item number 21, your lordship. Senior is having some personal difficulties, your lordship.
Learned counsel Ms. S.
S.
Tomana. On behalf of learned counsel Mr.
D. Chaudhary.
D. Chaudhary has paid for adjournment. Have you taken consent on from
We have
the
informed your lordship.
it is submitted that Mr. D. Chaudhary
Yes, sir.
is indisposed today.
Is having some personal difficulties.
Is having some personal difficulties. List after 2 weeks.
Obliged, your lordship.
May it please your lordship, in regard to item number 46, kindly fix the matter after
For vacation, my lord.
As agreed by both the sides, list this matter after Puja vacation.
okay.
But he has prayed, my lord, I have not prayed.
Okay, okay, okay.
I
Learned
take any
counsel
consent.
Mr. Yes, what is your name?
As the for
Yes,
the appellant,
doctor.
for the appellant.
Has prayed for adjournment. Learned counsel Mr. P. Sundi
Yes, Sunil.
is present on behalf for the respondents. List the matter after Puja vacation.
After vacation, my date may be fixed, my lord.
List the matter on 30 October.
Much obliged.
Item number 1.
Please, Lordship, this is a 482 bail application. This is a third time appeal.
Under sections,
103.
we'll call for the CD. Call for the CD, list the matter on from which police station.
Lordship from Tamulpur PS.
Tamulpur PS.
On 17th September.
Lordship.
Item 2 for admission.
May it please your lordship. Lordship, this matrimonial appeal has been preferred, your lordship. Challenge.
Yes, I'm still 50% I'll deposit.
You'll deposit. We'll start with the IA.
Lordship?
We'll start with the IA.
Yes, Lordship.
Learned
But
counsel.
we admitted and next I may be
Yes.
taken.
I will admit it,
Admit.
but it will be easier if we start with the IA. You want a stay order, no?
Yes, Lordship.
Yes, we'll admit it.
Yes.
Already made up my mind. I'll admit it. Learned counsel Mr. R. Gusame is present for the insurer, stroke applicant, and has filed this application under order 41 rule 5 of the CPC, praying for stay of the operation of the impugned judgment and award dated 28/5/2025 passed by the learned member MSCT Kuprachar in MSC case number 13/2020, as the insurer is aggrieved by the quantum of loss of dependency.
Loss of dependence.
Quantum of loss of dependency, full stop. It is submitted that there is every possibility that this appeal will succeed. I have also scrutinized the impugned judgment and order, full stop. Considering all aspects, the operation of the impugned judgment and award dated 28/5/2025 in MSC case number 13/2020 is stayed until further orders, subject to the condition that the appellant deposits 50% of the
Award.
award, 50% of the awarded compensation before the registry of this court within 4 weeks from
Court.
today. Itu likhi dia.
Obligation.
In terms of the above observation, this application stands disposed of. থাকিবলৈ দিয়া, এইটো পাৰ্টি শুনা নাই নহয়, disposed of নালাগে। এইটো লিখি দিয়া, learned counsel Mr. R. Goswami is present for the insurer, stroke appellant, to stop the first paragraph to the The appellant is aggrieved by the judgment and order dated so and so passed by the learned member MSCT so and so in connection with MSC case number so and so. Full stop. It is submitted that the appellant is aggrieved by the quantum of the award. Quantum of the loss of dependency awarded to the claimants. To stop, admit, issue notice to the respondents, returnable within 4 weeks. Call for the trial court records, list accordingly.
Comprehension.
Item 6.
Lordship, decision stated to the appeal, Lordship, we are involved in 2 vehicles, Lordship. Our vehicle was standing one and search it is.
I got to issue notice di diba. I had to issue notice di diba.
Other vehicle is had hit our standing vehicle, Lordship. So search is also filed against that vehicle, other vehicle, but we are held 50% liable. So our stand is that we should not have been settled with any liability, Lordship, in this case. And income is also taken in a higher side and disability was also taken in a higher side. That are grounds of appeal.
You are you are liable for 50% of the compensation amount.
Yes, our vehicle is held 50% liable, other vehicle is held 50%, but our vehicle of standing and searches was also filed against other vehicles.
You want to stay?
Yes, no.
Let the other side come.
But,
Because there are
we will
2 insurance
deposit,
companies,
we will deposit loss of 50% of 50%.
50% of the
Yes,
50%.
that may not be released also.
Learned counsel, Mr. AJ Sokia is present for the Oriental Insurance Company,
Yes,
who has been held liable for 50% of the, 50% of the, who has for liable for contributory negligence, who has been held liable for contributory negligence, and the insurer has been directed to pay 50% of the compensation amount. Who stop? What is your submission?
Lordship, our vehicle was standing one, Lordship. The other vehicle had.
It is submitted on behalf of the appellant, stroke applicant, that the decision was erroneously passed by the learned tribunal, as the vehicle insured by the appellant was a parked vehicle, whereas the accident was caused by the other vehicle, and there is every possibility that this appeal may succeed. It appears that stay of the impugned order may be granted. Issue notice to the respondents. Meanwhile, the impugned order dated so and so in connection with so and so case, MSC case number so and so, is stayed until further orders, subject to the condition that the applicant deposits 50% of the of the
50% of appellant's liability.
50% of compensation, 50% out of the 50% out of the 50% of the awarded compensation before the registry of this court within 4 weeks from today. Issue notice to the other respondents. Issue notice to the respondents. List on ke agoto list kori thoi diba. Eto dispose kori dia nai agoto. Karon pura puri expertise hoise to. A to appeal to Likidia, heard learned counsel Mr. AJ Sokia for the Oriental Insurance Company Limited, appellant in this case. Subset baki ki likhi diba, agree by the quantum, agree because of mechanism of dictation this look, a to contributory negligence so and so and likhi diba. Admit likhi diya, issue notice to the respondents, returnable within 4 weeks. Call for the trial court's record, list accordingly.
My apology, Your Lordship. Item number 2, Your Lordship. Actually, what happened? The next date fixed for execution on 16th, Your Lordship.
It won't be executed, so don't worry.
Can it be on 15th, Your
Yes,
Lordship,
it
with
can
the
be on
consent of
15th.
the other party, Your Lordship?
Don't worry, first day itself, it won't be.
It's not
executed.
first day, your lordship. It's
Okay.
4th or 5th.
All right.
On 15th, your lordship. With due
15
respect.
days.
Much obliged, lordship.
But that LCA won't come.
Else, 2 days before, your lordship.
Yes, yes.
Lordship.
15.
Much obliged, lordship.
Proceed, in this case, Lordship, there is no valid liability actions of the driver, but pay and recovery order is given, Lordship. We are challenging that pay and recovery order because as for after amendment, there is no provision for pay and recovery in the MBA, Lordship, present MBA, Lordship. This is our ground.
You are a driver, you are for the owner.
I'm for the Oriental, yeah, I'm
For
for
the
the
insurer.
interest company, Lordship.
Let's issue notice.
Yes,
Let's issue notice. Here we'll admit it,
yes.
but there we'll issue notice. Okay. Learned Counsel, Mr. A.J. Sekia is present for the insurer, stroke appellant. As the insurer is aggrieved by the order of pay and recovery, within inverted commas, pay and recovery, within inverted commas, passed by the learned tribunal in connection with MSCT case number so and so. In connection with MSCT case number. MSC case number 433 of 2023. By order dated 9/6/2025. Stop. Admit, issue notice to the respondents, returnable within 4 weeks, call for the trial court records, list accordingly. I to লিখি দিবা তাহলে applicant will লিখি দিলে আমি লিখি দিলাম
Lordship, LCR is called for, Lordship.
yes I to খালি admit লিখিব নালাগে
It to the lordship. Plus, in this case, the policy does not cover the risk of the pillion rider. It's just an act only or act liability policy. And that does not cover the pillion rider.
no third party risk
Lordship,
no third party
no third. Yeah, there is also another that, this is the main year, other is that he did not have a license.
We'll admit it and issue notice for all everything.
Lordship, in this case, can
As
also
part of
make,
stay, I'm not willing, let us issue notice. As it is, they will grant stay as soon as you deposit 50%, they will not grant, I'm
if I
saying.
make a deposit without any order for the release,
No,
then
no,
they have to come and apply. In that case, I can make an objection at that point of time also.
no, they will not raise any objection. As soon as you deposit, they won't raise objection, but let us issue notice. Learned Counsel, Mr. R. Goswami is present for the appellant. HDFC Argo Gun General Insurance Company Limited. The appellant is aggrieved by the.
Well, the only problem now is they say they might go for execution, then I'll have to come rushing here to the court again to stop it.
No, here MSCT case, they won't go so fast for execution. Only one date. If they won't turn up, then we'll allow the I. As the appellant is aggrieved by the judgment and order dated. 29/5/2025 passed by the learned MSC. Learned member MSCT, Chirang Kazalgaon. The appellant is aggrieved as the driver was not carrying a valid driving license.
Yes, sir.
And the policy of the vehicle, offending vehicle was an act only policy, not covering third party risk. Admit, issue notice to the respondents, returnable within 4 weeks, call for the trial court records. I to 10 admit
Obliged.
list accordingly. Item 9.
Wait, please, your lordship.
Yes.
My lord, here, my lord, the insured vehicle was found to be flight without permit, my lord. So that leads to a my lord, breach of MV Act, my lord, and no relief was granted to us. We are for the insurance company.
Learned Counsel, Mr. M. Sokia, no?
Madam.
AJ Sokia.
My
Learned counsel, Mr. A.J. Sokia is
my name is T. Kolita.
T. Kulta, okay. Learned counsel, Mr. T. Kulta is present for the insurer. Stroke appellant, who is aggrieved by the judgment and order dated
5/6/2025.
Yes. 5/6/2025, passed by the learned tribunal, Kachar at Silchar in connection with MSC case number 76/2020. Full stop. It is submitted that, what was the submission?
My lord, the vehicle was plied without permit.
It is submitted that the offending vehicle was plying without permit, violating norms, full stop. Admit, issue notice to the respondents, returnable within 4 weeks, call for the trial court records, list accordingly. There also will issue notice.
My lord, 50% maybe we are ready to deposit.
Had Mr. T. Kulta, learned counsel for the IRA, no, applicant who is agreed by the judgment and order dated so and so, passed by the learned MSC so and so. It is submitted, taken liquidible. The applicant has prayed for stay of the impugned judgment and order. Full stop. It is submitted that there is every possibility that the appeal may succeed. Full stop. Considering all aspects, the judgment and order dated so and so is stayed until further orders, subject to the condition that the appellant stroke applicant deposits 50% of the awarded compensation before the registry of this court within 4 weeks from today. In terms of the above observation, this application stands. Nalage. Issue notice liquidium. Nalage dispose kobe. Issue notice.
My lord, I disposed of my lord.
No, I will not dispose it of. As it is, I have passed ex parte order. Let them come. Let them raise objection if they want. I am sure they won't raise objection, then we'll dispose it of.
They will file petition for withdrawing the amount, my lord. Rather.
Yes.
I can take it. This is an appeal filed by the insurance company against the quantum of
Mm.
the.
I also, you want to press the I or should we? Should not?
Regarding I will deposit 50% amount, that's it. Stay maybe the under.
Okay. Heard learned counsel Mr. K.K. Bhatto for the appellant stroke applicant who has filed his application with as the appellant is agreed by the judgment and order dated 5/6/2025 in connection with MSC case number 93/2023. As by the learned tribunal, लिखिला ना सुनीतपुर टेस्टपुर लिखिला passed by the learned tribunal सुनीतपुर टेस्टपुर. Custom, it is submitted that what was your grievance?
That's it.
Quantum. What is your grievance for preferring the appeal?
Even since the monthly income was considered rupees 25,500 without any documents. Lordship.
It is submitted that the monthly income was assessed by the learned tribunal without any supporting documents. It is submitted that there is every possibility that the appeal will succeed. Considering all aspects, the operation of the impugned judgment and order dated so and so is stayed until further order, subject to the condition that the applicant stroke insurer deposit 50% of the compensation before the registry of this court within 3 weeks from today. Issue notice to the respondents. Can you লিখি দিবা list accordingly আৰু admit to লিখি দিবা খালি. Appeal to admit লিখি দিলে হৈ যাব বা stay system লিখিব নালাগে. Call for the trial court records.
Timing item 4 along with item number 50 of the supplementary clauses.
Oh, sorry.
Lord, appeal against quantum, my lord. 50% ready to deposit.
I'm the claimant, we may kindly be allowed to.
Withdraw. Both the cases.
No,
My lord.
that is a stay, Lordship.
Item number 50 is the IA for stay, my lord.
Stay.
Okay, item number 50 is the IA for stay.
And item number 4 is the main appeal.
Why it has come separately?
My lord, it was filed subsequently, my lord.
Okay, okay.
That is,
This appeal has been admitted, no?
no, my lord.
Not admitted.
Not
Today is the first day.
It was listed earlier, my lord, but the IA was not there. So.
There's a
today-
caveat.
Yes, Lordship, I am for the caveat. Caveat clement, Lordship. Only one clement, Lordship.
There's an IA for condemnation of delay,
That has
which
been
has not,
condemned.
huh?
That is
That is
condemned.
condemned.
Okay, okay.
Today for admission, Lordship.
Only for this deposit, only for stay,
Admission and.
Admission and stay.
admission and stay. Okay. Learned Counsel Mr. T. Kolte is present for the appeal and stroke insurer and learned
A.R.
counsel
Agarwal for
Mr.
caveat clement.
A.R. Agarwal
For
is present for
caveat
the,
clement, Lordship.
uh,
Caveat clement.
sorry,
Caveat clement, Lordship. Caveator. I am for
Okay.
caveat clement.
is present for the claimant
And for respondent number 3,
and learned counsel Mr.
R. Sharma.
R. Sharma is present for the respondent number 3. What is your grievance? You prefer this?
My lord, my lord, the negligence of, there are two vehicles, my lord. Negligence was pleaded against both the vehicles. But the learned member had first and liability, entire liability upon us, my lord. Despite there being.
The appellant is aggrieved by the judgment and order dated 7/8/2024 passed by the learned member MSCT Kamrup M. Guwahati in connection with MSC case number 836 of 2021 as the liability was fastened only on the appellant despite the fact that the claimant has alleged liability on both the offending vehicles. Full stop. Admit, call for the trial court records. List after preservation,
Lordship.
list after preservation.
Lordship,
Puja.
50% deposit we can leave allowed.
Yes, yes,
List after four weeks, Lordship.
after preservation.
After 4 weeks.
After 4 weeks, list after 4 weeks. I to লিখি দিবা, I heard Mr. So এইটো আৰু লিখি দিবা, agreed by the এইটো এইখিনি লিখি দিবা, the reasons to লিখি দিবা, ground খিনি একেখিনিয়ে লিখি দিবা. It is some, it appears that the
Caveat clement, Lordship.
impugn order may be stayed, thereby the operation of the impugned order dated so and so in connection with so and so is stayed until further orders subject to the condition that the applicant deposits 50% of the awarded compensation before the registry of this court within 4 weeks from today.
Clement may kindly be allowed to withdraw, Lordship.
Yes, yes, learned counsel for the claimants has subscribed for withdrawal of the 50% awarded amount to be deposited by the,
On
Insurer.
verification identification.
yes, yes, to be deposited by the insurer, who considering all aspects, the claimant is allowed to withdraw the deposited amount from the registry of this court, subject to the condition that the claimant executes a bond for verification by the registry of the, for.
Lordship, bond not required, it is only for quantum, Lordship.
There's no petition also,
What is
no petition also, I am passing an order.
Lordship?
So execution of a bond subject to the for verification by the registry of the claimant appearing to withdraw the amount, apportioned amount.
Lordship,
In terms of the
caveat
above observation, I has disposed of.
has to be discharged, Lordship. Caveat has to be discharged.
Discharged.
My lord,
A long time back it has been discharged.
my lord, in main appeal, my lord, notice may be allowed to be issued in respect of respond number 2 and 4.
Issue notice to respond number 2 and 4, yes.
In main appeal, my lord.
They are already here, no?
Yeah.
Call for a trial court records, likha ase, no?
Thank you.
Much.
11-12 after some time also.
Okay, after some time.
Yes, this is the
No,
third.
it will come out, don't worry, after some time.
Well,
It will come out, after some time. I'm here till the end, till 5 PM.
Your lordship, senior is having some personal difficulties, your lordship. He won't be able.
Lord, in this case, they have not served the copy of the appeal also, Lordship.
Yes, please serve the copy of the learned counsel, Ms. S. Soma has submitted that our senior is having some personal difficulties and has prayed for adjournment. Appellant to
Your lordship can fix any date after puja vacation.
appellant to serve copies of the appeal memo to the
Yes, sir.
respondent. Gustav Leonard.
R.K. Talukdar.
R.K. Talukdar is present on behalf of the respondents. List this matter after puja vacation.
Number 14 for orders. Item 14.
May I please, my lord? My lord, may kindly see the office note dated 31/7 of 95. The respondent number 1 is appeared. Respondent number 2, the notice has been duly served. And the LCR has also been received. So kindly this matter may come up for hearing. It has already been admitted.
It has come after 2011,
Yes, ma'am.
after 14 years.
Yes.
After 14 years. It disappeared.
Yes, my lord, respondent number 1 appeared.
Learned counsel, Mr.
A. Vishwakarma.
K. Vishwakarma is present for the appellants.
Yes.
Full stop. Office note dated 31/7/2025 indicates that notice has been served to respondent number 2. Full stop. The learned counsel for the respondent number 1 has filed vocal number. As the LCR is before us, list this matter for hearing.
My lord, can a date be fixed, my lord, if possible? Any date, my lord. After puja vacation.
Yeah, that did your current 2011 or price. There is this matter for hearing on board basi gol niki, all of basi piece of like gol gen niki. 13 November?
Okay, my lord.
Okay. This matter for hearing on 13 November.
30.
30. Easy. Oh, ठीक है sir.
I'm obliged, my lord.
16.
These matters have come up together.
Yes, lordship. The matter has already, this matter was.
Why? This is one is of 2016, one is of 2024. Why it has been clubbed together? Same out of the same.
Same accident, two insurance surgeons.
Same cause of action. Huh? Okay, okay, oh, there has been a mistake here. There is an
On your-
error here.
Yes, Lordship.
Now I have, now they have told me what the error is.
Yes, 1 and 2.
That in that covered case,
Yes, Lordship.
only that respondent number 1 and 2 have been mentioned, that is why.
Yes, Lord.
And then we have not mentioned that about the respondent number. I have not mentioned
Yes,
about
Lord.
respondent number 3.
And her
So
part is,
that money is
her part
lying.
is kept intact, Lord.
Yes, yes.
Her share is there.
Is she still alive?
That, Lordship, I don't have any idea.
So
because
shall we
if-
issue notice to the respondent number 3?
Because I don't have any role, Lordship. I have withdrawn my part. Otherwise, Lordship, every day.
Money is in the registry only.
Yes,
You have deposited the money, it's in the
Yes, yes,
registry.
you have deposited.
So what to do now?
So registry will issue notice if he is alive, then she is alive, then
Registry to issue notice. I'll pass an order, no?
that's
It will indicate here, the registry has brought to the notice of this court that the judgment and order passed by the learned MSCT. Judgment and order so and so, dated so and so, passed by the learned MSCT, clearly reveals that the quantum of compensation has been apportioned for respondent number 1, 2, and 3, whereas in this in the previous order dated so and so, it has been mentioned that the only the respondent number 2 and 3 were directed to
Respondent number 3. I'm appearing.
oh,
for-
respondent number 1 and 2.
I'm appearing for 1 and 2. I have withdrawn my share.
Respondent number 1 and 2 were directed to were directed it was directed that the compensation be paid only to respondent number 2 and respondent number 1 and 3. Full stop. It appears that notice has to be issued to respondent number 3 to accept the compensation apportioned by the learned tribunal for respondent number 3. Registry may issue notice to respondent number 3. এইটো তেনেকে থাকিব ডিসপোজ হয়ে গ'ল ন এইটো তেনেকে থাকিব এইটো আকৌ মাতি পেলাই সুধি লম ইয়াত নালাগে থাকক এইটো মাতি পেলাই সুধি লম কি কৰিম
item 17.
May please, I'm so sorry, my lord. From office note, my lord, 17/5/2025, I have not taken steps. my lord. Give me as a last chance.
yes sure
After 3 weeks, my lord.
Appellant stroke applicant to take steps to issue notice to respond number 3.
Yes,
Okay, office notice 17/5, no?
yes, my lord. 17/5/2025. I'll take a fresh steps.
Fresh steps will be taken to issue notice to respondent number 3.
No, my lord. 1, 2, 2A and 2, 2G.
Okay, okay, respondent number 1, 2A to 2G.
2G.
3, 1, 2A to 2G.
Obligation.
Is the matter after 3 weeks?
Item 18.
3 নহয় দেই
My lord, record not received so far the office note. Bill is already.
Oh, records are not received, no?
Received, yeah.
Okay.
My lord,
Records as called for is not received. Issue reminder to transmit the records of this is civil appeal.
my lord,
Records of trial court record as well as the appellate court record. All right?
my lord. My lord, one thing, my lord, here, the respondent 2 has expired. But her 2 sons are already party in the case. So, my lord,
You want to issue notice?
not required at this stage. Just I am giving the, informing the court, my lord.
Okay.
The respondent number 2 expired,
They
but
have
his
already
sons are already party in the
Okay.
case. Not necessary to sub.
Not now.
My lord.
It's okay.
Privilege.
List after
After
3 weeks.
After vacation, my lord.
List after puja vacation. All right.
Item 19.
Wait, please, your lordship. Your lordship, service is complete in this matter and there is a delay of 10 days. So the delay may be condoned, your lordship.
No, no. Let the other side come.
Okay, Your Lordship.
Have you issued notice?
Yes, Your Lordship. Service is complete upon 1 and 2.
Upon 1 and 2, it is complete.
Yes, Your
Then
Lordship.
we can condone the delay.
Your Lordship.
Where is a condonation petition? One is for something else, stay, I think.
Beg your pardon, Your Lordship.
One 3893 is for stay.
Yes, Your Lordship.
Then which one?
3892
Two. Okay.
for delay.
Where is the office note?
Your Lordship, office note dated 13/5/25.
Oh, Lazima order. Let me read the order
Yes,
first.
yes.
What about respondent number 1?
Respondent, as per order dated 18/12/2019, service is complete upon respondent number 1.
Okay. All right. I'm just checking the judgment because it has come from Dibrugarh.
Yes.
So I'm checking whether I have passed the
okay.
order or not. I have not passed the order. Our learned counsel, Mr. S. Doctor,
Yes, Lordship.
for the applicant, Moina Robidas, who has filed this application under section 5 of the Limitation Act 1963, related to order 41 rule 3A of the CPC for condoning the delay of 10 days in filing the connected second appeal against the judgment and decree dated 6/7/2017 passed by the learned civil judge Dibrugarh in TA number 42 of 2015. Full stop. The order dated 18/12/2019 of this court indicates that notice has been served to respondent number 1, whereas the Lawazima court's order dated 13/5/2025 indicates that notices have been served to respondent number 2. Full stop. The respondents are not present before this court. It is submitted on behalf of the applicant that where is the cause of delay?
Your lordship, some communication difficulties were there.
In which paragraph?
Page number 5, paragraph number 6, your lordship.
That the judgment and decree was passed on judgment and decree in TA 42 of 2013 was passed on 6/7/2017 and the copies were obtained on 24/7/2017. Full stop. The NDPS council received the certified copies on 2/8/2017. Full stop. The petitioner, being a resident of Dibrugarh, could not immediately contact any council at Guwahati to discuss about the matter. Full stop. However, the petitioner could contact the present NDPS council during the first week of September and was advised to prefer a regular second appeal before this court. Full stop. The papers were handed over for drafting the second appeal on 15/9/2017, and finally, this resulted in the delay of 10 days in filing the connected appeal. Full stop. It is submitted that there was no mala fide or dilatory tactics on the part of the appellant. Full stop. It appears that sufficient grounds has been shown, thereby delay of 10 days is condoned, registry to connect the register the okay.
What's up?
It's already registered. Delay is hereby condoned. In terms of the above observation, this application stands disposed of.
What's up?
Edu hogol niki? Edu nalage, edu nalage. Edu stay karon ase. Notice aro mane
Item 22. Item 22.
May I please? Office note dated 26/11/2024, my lord, it says that 9, 10, 11, 12 has unserved notice. But, and we have instructions, my lord, respondent number 11, 12, they already expired, along with respondent number 7, they expired, my lord. So we need some time to complete their legal heirs as part.
Learned Counsel Mr.
SS Ahmed, my lord.
SS Ahmed is present for the appellant. Office note dated 26/11/2024
26/11/2024, my lord.
indicates that
9 and 10 received.
no service report has been received in respect of respondent number 12.
She expired, my lord.
Full stop. It is submitted that respondent number 11 and 12 have passed away.
Yes, 11 and
11 and 12 have passed
and
away.
7 million.
7 also.
Yes, ma'am.
The respondent number 7, 11 and 12 have passed away and the learned counsel has submitted for some time to for substitution.
Yes, ma'am.
The respondent number, all the other pro forma respondents are the legal heirs of respondent number 7 only, so it might not be necessary.
7 is not required.
7 is will not be required.
Substitution of the legal heirs of the respondent number
11
11
and
and
12.
12. 11 and 12.
11.
List the matter after preservation.
Yes, madam. Exactly.
My lord,
God bless me.
in this case, my lord, our name may be strike out.
No.
I have
why-
given
why-
the entire record to my lord.
Okay, okay.
I have given the NRC. my lord. From the call list, the E. Hussain and me, the A. Rahman, may kindly be deleted.
Learned counsel Mr. T. Hussain is present and has
A.
submitted.
Rahman, I am A. Rahman.
A. Roman, okay. Mr. A. Roman is present and has submitted that that they are not representing the appellants anymore,
My lord,
as the appellants are being represented by the present counsel, Mr.
S. Ahmed. my lord.
S. Hassan,
S. Ahmed. my lord.
S. Ahmed. The names of learned counsel, Mr. Which item 22, no? Whose names have to be?
E.
covered?
Hussain and A. Rahman.
E. Hussain and A. Roman may not be reflected in the cause list.
My lord,
May not be reflected in the cause list by the registry. Okay.
my lord.
Not to be reflected, basically. Not to be reflected by the, in the cause list by the registry.
Lordship,
Yes, yes.
for the plaintiff and for the petitioner,
Hmm.
we'll take fresh steps upon this matter, your lordship.
Okay.
Kindly 4 weeks may be granted.
Learned counsel, Mr.
And thus,
N. Das is present. To stop, fresh steps to be taken to issue notice to the whom?
respondents,
Respondents. One respondent, no,
all respondents,
to the respondents, list after 3 weeks.
4 weeks.
List after 4 weeks.
Item 24.
May I please, your lordship?
Hmm.
That's why I'm saying 2 weeks time for taking steps upon the substitution of the legal heirs of the deceased 6, 7, 11 and 13.
Learned counsel, Mr.
A. Banerjee.
A. Banerjee has prayed for 2 weeks time to take steps to
Upon
the
the
substituted legal heirs of
legal heirs of respondent number 6, 7, 11 and 13.
6, 7, 11 and 13. Okay. Okay. Learned counsel, Mr.
M. Hussain, my lord.
M. Hussain is present for respondent number 1, 3, 4 and 10.
9 and 10.
1, 3, 4, 9 and 10.
Yes,
List. Given weeks, list after 2 weeks.
most of the dinner.
Filed an application for violation of injunction order, and report was called for. The report is there, but the report is, lordship, absurd because only view that the disputed plot of land, lordship. That is so far as disputed plot of land over which injunction is there, lordship. In front of that, there is a government land, lordship. With the house was constructed over the government land.
Not over the disputed.
Not over the disputed line, but report is, lordship, something, it is not clear.
Absurd.
It is not clear
Not
from the
clear.
report. They only say that we have gone to the spot visited, found one house with new tin shed and bamboo, that much.
Lordship,
I'm the newly engaged counsel for legal aid, my lord. Respondent number 1. His counsel had withdrawn from the case. I have been appointed newly as such for respondent number 1 in the appeal. And in the IA was filed by Asit Malika only.
Yes, yes.
Apni Asad Malika.
No. It was filed by them.
Yes, it was filed by me.
They have alleged the violation of the injunction.
So a report was called for, I had produced. If the report has come, my lord, I have not gone through the report. And some photographs are there, my lord, I need some time to file an additional affidavit. Geotagged photo is there in the file, which I need to place on record, which will aid this court in disposing of the I. It's a violation application, injunction.
all right.
Actually, I've been newly engaged as such,
Okay.
some time may be given.
So when was the order passed for report?
It was earlier, Lordship, more than a year.
Last time I have passed the order only to send reminder,
Yes, Lordship.
but somebody else has passed. the
Earlier, it is
report.
much more earlier, Lord. And 6. Plus, perhaps.
It was passed on 28/11/2022.
Yes. But we have filed and written objection also.
I cannot find a report here in this
It is marked as X, Lordship, like a
marked as X.
X. Lordship, in the front side. Last slide. Like, yes.
Oh, yes. We'll see if we can rely on his report. Let him file the objection.
Let him.
Yes.
Because Lordship, so far as report is concerned, Lordship, it did not state.
We'll have to check with the lower court record, plain
Yes, Lordship,
schedule and everything.
everything.
We'll have to check.
Ah,
Let him file the objection,
Let him file.
then we will go through it.
Yes.
Learned Counsel, Mr. U. Doctor is present for the appellant stroke applicant. No, appellant, applicant, no, right? Appellant, what is his name? Appellant's name?
Appellant, Lordship, it is Susila Malaga.
Appellant, Srimati Susila Malakar.
It is appellants, Lordship, there are.
Appellants, okay. Srimati Susila Malakar and
And
others.
others.
Srimati Susila Malakar and others. And Learned Counsel, Mr.
K.R. Borua, madam.
A.R. Borua is present on behalf of
Respondent number 1.
the respondent number 1, it is submitted that the Learned Counsel is newly engaged and has prayed for time to go through the
I'll file an additional affidavit, ma'am. Some photographs. are there.
prayed for some time to file additional affidavit. Okay. List the matter after 2 weeks.
After vacation.
State also there, Lordship.
Learned Government Advocate, Mr.
IA 1522 5 to 9. Respondent number. In appeal 6 to 8.
Okay. Learned Government Advocate, Mr. T.R. Gogoi is present for the government. For the revenue authorities or for the government?
He is representing revenue authority, government.
Okay, for the revenue authorities.
Madam, after vacation, madam.
Huh?
After
List the
vacation.
matter after puja vacation? Okay.
Item 26.
Wait, please, also. Well, answer notice has been received, madam. Upon the respondent too, madam.
Answer notice has been received.
Madam. Office note, my lord. 21/7/2020. Reflected. We have taken press statement. My lord,
My lord, may I make a prayer, my lord? My lord, kindly peruse the office note, my lord, 3/6/2025.
Hmm. Yes.
The details, my lord. The wife is there, my lord, but the person is, my lord, untraceable, my lord. And my lord, this is the, my lord, restoration petition, my lord. There is a delay for restoration, my lord. Delay is condoned, my lord. In delay, my lord, we have already taken step, my lord. And my lord, notice has been completed, my lord. Only, my lord, once he is, my lord, strike out, my lord. He is, my lord, demise, my lord, and my lord, his wife, my lord, left the matrimonial house. My lord, in the view of the above, my lord, the service, my lord, if my lord convenience, my lord. My lord, this is the order, my lord, of delay condonation order. My lord, the divorce. In paragraph 2 and 3, my lord.
Same case.
Same case, my lord, connected, my lord, IAS.
P247.
My lord,
I'll just check and see, compare and see if they are the same parties, then I can,
my lord, my lord. Same party, my lord.
same parties.
Same thing, my lord. And our prayer in this, I am, my lord, restore the, my lord, appeal, my lord. In the view of the, my lord, delay is already condoned, my lord.
No, you'll have to serve in this case. Can't help it, you have to serve in this case. It's okay that it was decided in your favor.
My lord. But my lord, this petition is only for the restoration, my lord. Control already,
I understand, yes, yes.
already step was my lord. Service was completed in the IA, my lord.
Only one who has not, respond number 1A, 1B, which respondent you are saying that is yet to appear?
Respondent number 2, my lord.
Respondent number 2, okay.
My lord.
Address not found, okay.
Address not found, my lord. No. His wife, my lord, no, my lord, about the my lord. His wife informed, my lord.
Respondent number 2 was, what is her name? What is his name?
His name is, my lord, Dango Lora Das, my lord.
Dangolora Das.
My lord.
Okay. There's another way of serving notice, no?
Oh, another already completed other.
By hanging it in the.
Only in respect of the respondent number 2, my lord, he is not trace out, my lord. And my lord, 1C is my lord strike out, my lord, in the IA, my lord. And my lord, our prayer same is there in this IA, my lord. Strike out because my lord, he is my lord passed away, my lord, and his wife already left the matrimonial office, my lord. No legal heir is left, my lord.
Which
And
one? That is respondent number?
1C, my lord.
That doesn't matter. We will pass an order.
And my
respondent
lord,
number 1.
only my lord, in respect of respondent number 2 is my lord services, my lord, not completed. In this IA, my lord.
Yes,
But
yes.
earlier IA already they have received, my lord.
They have received, yes.
This is the contradiction. And in the view of the my lord, earlier IA, my lord, the service is completed, my lord, in this case, my lord. Same case, my lord.
I'll have to ponder over it.
My lord.
Let me think over it.
My lord.
Okay.
Oblige, my lord.
Mm.
Standing at 11.
26, no?
Yeah, file. May I please allow, sir? My lord, this is the case, my lord. Where is my lord? Two cases, my lord, on the same. Your lordship, one has been rejected and another has been granted bail, my lord. That is the case, my lord. And from me, my lord, the recovery was 311 gram, my lord. And the prime accused who has been enlarged on bail, my lord. And status of the case, my lord, is that, my lord, case is not to the mark of the satisfaction, my lord. I've got a downloaded copy, my lord. This page, my lord, status, present status. And I am behind the bar, my lord. It's my lord 8/10/24. On the last occasion, my lord, since 8/10/24.
6/10/24.
8/10. 8/10/24.
Okay.
8/10/24, I am behind the bar, my lord. And the case also does not proceed accordingly, my lord, that satisfactory level, my lord. To that effect, my lord, since it is NDPS, my lord, I have been, it has been recovered from me only page 26, my lord. Altogether, my lord,
it will be, my lord, 311 gram from me. And from whom, my lord, the major quantity have been recovered, my lord, they have been enlarged on bail on the strength of, my lord, the notice part, my lord. This honorable court granted bail, my lord. And long incarceration, my lord, your lordship has passed me the similar identical case, my lord. Wherein it will be a long incarceration between Hussein Ali will do. No. Hussein Ali, Arota Asil do. Itu কি নাম? হুসেন আহমেদ আরো একটু এটা দিয়ে আরো যেটা আছে একটু দিয়ে হিমাদ আহমেদ এটাও দিতে দুটাই দিই so far my lord Hussein Ahmed is concerned, my lord, which I am supplying, my lord. Your lordship has granted bail on the long incarceration, my lord. There are 14, it says, my lord. Your lordship has granted bail, my lord, due to long incarceration, my lord, relying on several other cases, my lord. Similarly, my lord, Ahmad Hussein also, my lord. Your lordship has granted bail. Para 12, my lord, basically basing on the para 12. And that too also, my lord, relied on decision of the apex court. Your lordship has passed the order, my lord. Since, my lord, all the persons is out, my lord, and I am not a professional, this is my first time case, my lord. I made an inquiry, my lord. There is no earlier incident against me, my lord. Under any circumstances, my lord, since charge sheet has been filed, my lord, and there is no possibility I can tamper with the evidence because most of the evidence are the government officials. I will not tamper and I will appear regularly, my lord, under any stringent conditions. And I am the only one, my lord, who is behind the bar.
Okay.
That is, my lord, considering the length of detention, my lord, since, my lord, to face my trial, my lord, I'll face it, my lord. I could not even engage properly my lawyer also, my lord. Without discussion, my lord, I cannot, my lord. Whoever comes by that way, my lord, we are running. So considering that, my lord, length of detention, my lord, since, my lord, the majority part, my lord, who has been already granted bail, my lord, recovered huge quantity, my lord, and from me, my lord, only 311. Under any condition, my lord, and that too, my lord, not from the concise position, my lord. It has been recovered from my house. That is the one. That much, my lord, lordship, kindly consider the bill, my lord.
Lordship, from him, lordship, if it is 311 grams, lordship, and it is sufficient.
That is
It is commercial quantity, lordship, and it is not like that. Not like that, lordship. It was not recovered from him. He led the police personnel to his home. He identified where he kept it. Thereafter, police seized it from his home, lordship. So it was from his home, lordship, and he led the entire team. That let's say I have kept it in that place, and thereafter police recovered it. So lordship, so he is fully aware about what he was done, and when the amount of the seized article is commercial quantity, there is no scope of giving bail protection to him, lordship. And subsequently, lordship, what that long incarceration, lordship. That is, lordship, in nowadays, lordship, and new one, lordship, that is, lordship, the state of Karnataka versus Darshan, etc., lordship. In that case, also, lordship, and that long incarceration has been discussed, lordship, and length of long charge sheet of filing of charge sheet and long list of the witnesses, that will not come, lordship. And even, lordship, Honorable Apex Court has, yes, the Honorable Apex Court has, lordship, also observed in this judgment, lordship, that, lordship, this court, while granting the, taking the bail petitions, court should not, the High Court should not any mini trial, lordship. Only on whether prima facie, this court has to see, lordship, whether there is a material against him or not, lordship. And here in this case, lordship, prima facie, lordship, I have already trademark all the required documents, lordship. And lordship will find it, lordship, that his involvement is there. Prima facie, he is involved. Prima facie, he was done that NDPS Act, lordship, and NDPS substance he was scanning.
But you see, this trial has not commenced.
Lordship, trial has to commence, lordship. Lordship, here in this case, lordship, here, lordship, charge sheet file on 24/25. And for PWs, it was fixed on 23/5/25. Thereafter, record is not here. So
No, he has given.
I have given
download.
downloaded copy. After that, I have given.
when charge sheet is filed 24/25,
Appearance stage, man.
24/25, lordship, charge sheet is
Download কৰি দিছো।
charge sheet is filed 24/25, lordship. Thereafter, lordship, some procedures are there, lordship. And court cannot jump, lordship, that lordship for speedy trial by leaving all the other court proceedings only because they are the NDPS, the persons they are doing the NDPS Act, so they should be released. Their case should be run fast, lordship. It is not like that, lordship. Courts are also overburdened, lordship, and it is on if it is on April, charge sheet is filed, and today it is fixed for evidences, lordship. PWs may not come up. All the times PWs may not come on the first day, second day, because PWs are also from one place to another place. PWs are moving, lordship. Official witnesses are, lordship. So, lordship, only because of that, in the present new judgment, lordship, that is lordship, Darshan, etc., lordship, it is discussed, lordship, in para 20.4, lordship, that lordship, long incarceration and long list of witnesses, filing of charge sheet, those are not the grounds for allowing bail applications, lordship. And section 37 embargo is also there, lordship. Section 37 is also there, lordship.
The person, my lord, who from home, my lord, 12 kilo has been recovered. He's on bail, my lord.
On one count, lordship,
1 kg,
All this. I'll consider all this.
Lordship, lordship.
I'll pass an order later.
Lordship.
lordship.
এইটো ক্লিপ মাৰি থব লাগিব দুদিনৰ জাজমেণ্ট হেৰি আৰ্গুমেণ্ট
Lordship.
দুদিনৰ আৰ্গুমেণ্ট আছে দেই টেম্পাৰ নহ'ব
Last occasion, the regular bill, 46 days behind the bar. Lordship have last occasion gone through the case there and Lordship have there are some models to be still, Lordship. So
one person who was kidnapped, lordship, he was brought to Tripura, lordship, subsequently some he was badly tortured.
Then some carpets were supposed to be delivered to one person. It was delivered.
Remember that.
Lordship. Now, Lordship, only the thing is that regarding the custody, Lordship, detention, that 46 days at that point of time, it was about 30 days or like that, Lordship. Therefore, it was postponed till today, Lordship. Kindly, Lordship.
On that day, lordship called for the medical report, lordship. That medical report I have not received, lordship. CD.
You see the CD?
I have seen.
They were assaulted, no?
They were assaulted, lordship. That medical report we have not received.
We haven't received the medical report. Without medical report can be granted, I think.
Because, lordship, but the torture he has been done, lordship, 30 days thereafter, lordship, not only the torture, lordship. 10 lakhs rupees was demanded, lordship. 5 lakhs has been transferred to them, lordship. They have taken the 5 lakh rupees they demanded, lordship. So, lordship, 45 days is not so much.
That is for the carpet, Lordship. That Lordship have gone through the case there on last occasion, Lordship. It is completely a business deal, Lordship, between the both the parties, Lordship.
No, it's
some wrong was done, Lordship.
They had no business. They have kidnapped these people and they have given them third degree torture. Each and every day. They have no business to do all this.
46 days, Lordship. I am not the merit of the case, Lordship.
I remember the conduct.
I have seen, I have control, lordship, but the medical report is not available, lordship.
Kindly allow local person to know, sir, the victim is already recovered, Lordship, that what happened, Lordship.
After getting third degree.
No, it was very unfortunate, Lordship. What happened, Lordship, for that 46 days he is behind the bar, now he will face the trial, Lordship. He also will get the same punishment, Lordship, facing the trial and all lordship. That 46 days already behind the bar lordship. Some rightly very unfortunate lordship what had happened lordship.
Unfortunately for the victim. not
No,
for the
definitely,
lawyer.
I agree, Lordship. I do not support this petition or
Let that
lordship.
medical report come. also.
Only,
Medical
no,
report is not.
Lordship, Lordship will kindly see 40 local person, not habitual offender, Lordship. It is due to a transaction, they have chosen the
How
wrong
you
way.
cannot say, how you can say whether he is habitual or not also.
No, that will
When
reflect in
person
case
is
diary, Lordship.
doing such kind of a act,
Then what it is.
bringing one person from here to Tripura, they are
What
torturing in 3rd degree.
done, Lordship. It didn't
We
mean
cannot say also he is whether he is
diary,
habitual or not. also.
If it had been a habitual Lordship, then it will definitely come in the
And that
case
should
diary.
be innocent persons.
And even thereafter also they have taken money from 5 lakhs
Money,
rupees.
Lordship, that is admitted fact,
Okay, I'm
Lordship.
granting bail.
Lordship.
Under your objection, heard learned counsel Mr. S. Muni for the petitioners. For one petitioner,
One petition.
Sami Mohammed, alias Mohammed Sami Mohammed, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as he is behind bars. Okay, I'll come back and pass an order.
Lordship.
Materials.
Lordship, I have some matters at
Yes, yes, you
25
can.
minutes.
Shemi Mohammed, alias Mohammed Shami Muddin, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as he is behind bars since 20/07/2025 in connection with Patharkandi PS case number so and so under section so and so. Had Mr. P.S. Lofer, who has raised serious objections stating that there are incriminating materials in the case diary against the petitioner. It is submitted that investigation may be adversely affected if the petitioners are admitted to bail. I've considered the submissions at the bar. The FIR unfolds that two victims, namely Alal Uddin and C. Faiz Uddin, were kidnapped. On 8/2/2025. Full stop. The informant learned on 12/2/2025 that the kidnapped victims were confined at Sunamura, SUNAMURA, in Tripura. Full stop. The petitioner is involved in kidnapping the victims and demanding rupees 10 lakhs as ransom for their release. Full stop. The learned additional PP has submitted that the victims were also subjected to torture and harassment by the petitioner. Full stop. I have scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the petitioner. Full stop. I have considered the length of detention. Full stop. Investigation has also progressed substantially. I have considered the submission that the petitioner is willing to abide by any stringent bail conditions if imposed upon him. Considering all aspects, petition is allowed. The petitioner is enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction Karimganj, no?
Sri Bhumi, Lordship. Sri Bhumi
To
Assam,
the satisfaction of the learned CJM.
CGM.
Sri Bhumi, under the condition that the petitioner shall appear before the IO on every fortnight till completion of investigation. Number 2, the petitioner shall refrain from such activities with which he is alleged. Number 3, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner, send back the CD.
Much obliged, Your Lordship, much obliged.
Number 27 for August.
May I please? As per office note dated 16/5, LCR of title suit is yet to come, Lords.
Okay. Okay, we'll need the LCR.
Okay.
Others,
All
appeal has come.
title appeals, LCR already come.
Okay. Original LCR of, original trial court record of title suit number, what is the title suit number?
Title suit number
Not received.
46 of 2013.
46 to 2013 is not received. Issue reminder, list the matter on after vacation.
After
List the
I'm
matter
appearing
after
for
vacation.
respondents 2 and 3. I'm appearing for respondents 2 and 3. K. Bhattacharya.
Okay.
Lordship, date may fix, Lordship.
Okay. Lawyer counsel Mr. BC Das, beginning of Lihidiba. BC Das,
SS wrong.
SS Roman is present for the appellant. Learned government advocate
That's
Mr.
K. Bhattacharya.
PK Bhattacharya.
K. Bhattacharya for 2 and 3.
Government advocate
Yes.
is TK, no?
K.
KK Bhattacharya is present for the respondent number 2 and 3.
Yes, Roy, for respondent number 1.
Learned counsel Mr.
Yes, Roy.
S.
Roy.
Roy is present for respondent number 1. List the matter after puja vacation,
Yes, sir.
or you want a date?
Date here.
Date is 24th October.
Much obliged.
Item 28.
May I? Yes. After the Lojima Court's order dated 28/4/2025, my lord, we have taken steps, my lord, on the respondents, my lord. But office note has not reflected.
It is submitted, the steps have been taken to issue notice to the respondents after the Lawajima Court's order dated 28/4/2025. Full stop. Service report on the respondents are awaited.
Yeah, wait.
List the matter
Office
after 4 weeks.
4 weeks.
4 weeks?
Yes, my lord. My lord, I'm appearing for respondent 1E and 1F.
Okay. Learned counsel Mr. Beginning of Lihidiba. B. Ahmed.
K. Uddin, my lord.
Mr. K. Uddin is present for the petitioner. Applicant Lihidiba. Applicant. Learned counsel Mr.
G. Imtiaz, my lord, on behalf of Mr. A. Iqbal.
G.
Imtiaz.
Imtiaz is present on behalf of learned counsel Mr. A. Iqbal, representing respondent number 16 and 17.
Yes, ma'am.
Item 29.
Maybe item 29 for time being lost.
Time being?
The senior is engaged in put number 16 lost.
For time being.
Item 30.
May I please? Worship, in this matter, Wakalatnama has been filed for respondent number 1, 2, 3, and 5, Lordship. 4 is
Lordship, regarding respondent number 4, I will take instruction, Lordship.
Okay. Same family.
Yes.
simply brother and
Yes, Lordship.
sisters. They are all,
Learned counsel Mr. M.K. Hussain, no?
Lordship, for
Is
the
present for the appellant. Learned counsel Miss
K. Bora.
K. Bora is present for respondent number 1,
One,
2, 3, and 5, and is submitted to obtain instructions of relating to representation of respondent number 4. This is the matter after puja vacation.
Yes. Lordship. Highly obliged.
Item 31.
IA for
My lord, here I am for setting aside abatements in respect of the restaurant number 5 and the IA number, my lord, 1467 is for my lord some delay, my lord, for setting aside abatement.
Oh. Setting aside abatement.
Yes, my lord, 1467.
1467 is the first one.
Yes, my
It
lord.
will have to be taken up initially.
My lord, next, my lord,
Then 1469.
then my lord, 1470.
Okay,
Thereafter, 1469.
okay, okay. Then 1242.
So in the main RSA, there was a delay, 76 days.
Take up the other IS not listed.
And in this case, Lordship, I have got instruction from my client. They also know that the matter has been amicably settled between themselves.
467.
Amicably settled.
Yes, Lordship.
But though immediately settled, my lord, but
No,
there
you
must-
see, I'll have to take up only one IA, 1467.
My lord, my lord. Yes, my lord.
1242.
Yes, only one, my lord.
1242 is the delay continuation in the main RSA. And during pendency of the delay continuation petition, respondent number 5
died, my lord.
died, Lordship. And in that process, some delay, abatement of the abatement and substitution, that has been pending, Lordship.
1467 আর কোন কিটা হয়েছে 1242 1470 1469. All right. Learned Counsel Mr.
M. Hussain.
M. Hussain is present for IA number 1467. Huh? M. Hussain is present for the applicant who has filed his application under Section 5 of the Limitation Act 1963 with prayer for continuation of delay of 330 days as on 26/6/2023 in filing the connected application for setting aside the abatement petition. Abatement petition, setting aside the abatement of respondent number
5, my lord.
respondent number 5.
5.
5 only.
5, my lord, 5.
Learned Counsel Mr.
D. Kolita, Lordship.
D. Kolita is
Wherein the
for
respondent number
respondent
1, 2, 3
number
and 4.
1, 2, 3, and 4. Full stop. It is submitted on behalf of the applicant that the engaged counsel of the applicant receive information regarding death of respondent number 5 on 20/04/2022 from the engaged counsel from the advocate of respondent number 5.
Yes, my lord.
Nalage from the engaged counsel of respondent number 5 nalage. The engaged counsel was unable to communicate with the applicant on 10/5/2022 for for all the details relating to the legal heirs of respondent number 5. Finally, full stop delay. Finally, not finally to nalage. It is submitted that the applicant who has been widowed is suffering from acute financial hardship and she was unable to engage any advocate when managed bus fare to communicate to Guwahati. However, finally she could manage to take the assistance of a co-villager to accompany her to Guwahati and supplied the necessary information relating to the legal heirs of respondent number 5. Full stop. This resulted in delay of 330 days. Full stop. The learned counsel for the respondents number 1, 2, 3, and 4 has no objection. Full stop. Comma. If delay is condoned, stop. There appears to be no malafide on the part of the applicant. Full stop. Sufficient grounds have already been shown. Thereby, delay is condoned. Delay to file an application for setting aside the abatement, no?
Yes, sir.
For setting aside the abatement of respondent number 5 is hereby condoned. In terms of the above observation, this application stands disposed of. Then we'll come to which application?
My lord, then we come to abatement, my lord, 1470.
Learned counsel, Mr. So-and-so is present for the applicant. Agar नाम के नाम ही लिखी दिले हो जाएगा applicant. And learned counsel, Mr. So-and-so is present for the respondent number 1, 2, 3, and 4. Full stop. This application has been filed at 1470, huh? Under order 22, rule 9(2) of the CPC for setting aside the abatement of the deceased respondent number 5. What will be the name of the deceased respondent number 5?
My lord, sorry, Saifullah Sheikh. In my lord, 1469. This is respondent number Saifullah Sheikh, my lord.
Saidullah Sheikh.
Saifullah Sheikh.
What will be the name of the respondent number 5 was it Saidullah Sheikh? This is respondent number 5, Saidullah Sheikh. The learned counsel
Saifullah, S-A-I-F-U-L-L-A.
considering all aspects. The abatement of respondent number 5, Saidullah.
Saifullah, my lord.
Saifullah Sheikh.
My lord, in second page, my lord, respondent number 5. In IA number 1470.
In terms
second
of the
page.
setup, in terms of the above observation, this application stands disposed of. Then
And then my lord, substitution, my lord. Next, 1469.
Heard learned counsel Mr. So-and-so for the applicant and learned counsel Mr. So-and-so for the respondent number 1, 2, 3, and 4. This application is filed 1469, huh? File under order 22 rule 4 of the CPC for substitution of the legal heirs of defendant defendant is respondent number 5, no?
My lord.
Defendant number 5 is respondent number 5.
Yes, my lord.
Defendant number 5 stroke, respondent number 5 stroke, Saifullah Sheikh. In connection with IAC number 1242 stroke 2020 arising out of RSA number 3773 stroke 2020. The learned counsel for the respondent has no objection. Thereby the legal heirs of Saifullah Sheikh, namely, have you given the name?
Yes, my lord.
Namely, page number 5, application page number 5, 5A to 5G likha hai naam.
5A, 5B, 5C,
Are
5C.
substituted. Full stop. The respondents or the applicant to submit an amended cost title. So it will be this.
Yes, my
They'll
lord.
have to be included in the IA also.
My lord, yes,
Amended photo.
in IA.
Cost title in the connected RSA and the IA.
Yes, ma'am. Highly.
In terms of the above observation, this application stands disposed of. RSA number 2 did huh? IA 1
RS,
to 2.
filing number.
Nine.
On the last occasion, appeal was admitted. Friend has been already represented both respondents. LCI is also here. So matter may be posted for hearing after puja vacation.
for after Puja vacation.
For hearing.
I mean,
Lordship, actually, the copy of the IA was not furnished to us, Your Lordship.
okay.
And in the meantime, that was not intimated to the trial court also, Your Lordship. In the meantime, an execution proceeding was conducted, initiated, and an order was passed by the trial court, Your Lordship, and the the agreement, the plaintiff was to pay 25 lakhs rupees to the defendant, original defendant. Your Lordship. That money has been deposited in the court, Your Lordship. This is the order of the.
But as per my instruction,
That was
after
not.
passing of this order, I prepared the certified copy and sent to the party. And as per my instruction, they have submitted the court.
That was not.
And however, my lord, as because the judgment is already stayed till today. So it is the till the execution, final execution, which is to be executed the salary as well as the receipt of the payment, both is to be done. So that is not done, I think.
Money
as
has
per
been
my
paid, Your
instruction-
Lordship. Money has been paid, draft salary has been deposited in the court, everything has been done. Because the stay order granted by this honorable court was not intimated to the trial court, Your Lordship.
As
On
per
three,
my instruction,
three
it was
occasions, on 3 occasions, Your Lordship, case was posted for orders, and that was not intimated, so there was no wrong in passing of the order.
But it's okay. There's no wrong in passing the order, but this will continue.
Yes, yes.
I thought, yeah, I thought that was, everything has been settled. But there's an order of stay.
Yes.
But this will continue. We'll fix it for hearing then.
Exactly. That may be continued, the stay order.
Stay order may not be continued because it has become infructuous, Your Lordship.
No, not infructuous, because till the execution of the salary by me or by the court, the matter cannot be executed finally by. So that is still pending execution, I think. Because as per my instruction, the order of
In
stay.
hearing, we will decide about the stay because now no point because this stay is continuing.
Yes, that is why stay to be continued.
So.
And if
We'll
some,
dispose of this appeal along, dispose of this IA along with the appeal.
No, Lordship.
Learned Counsel. Mr.
Immediately after the vacation, Your Lordship.
Yes, yes. Do you want a date? We can give you a date. Learned Counsel, Mr.
DK Nath. DK Nath.
DK Nath is present for the appellant and Learned Counsel, Dr. R. Sharma
R. Sharma.
Is present for the respondent number 1 and 2. This is matter for hearing on.
Well.
As the records are, trial court records are before us, this is matter for hearing on 28 October.
28 October.
Yes.
In the meantime, my lord, the stay
Meanwhile,
continue.
the interim order shall continue. Meanwhile, the interim order shall continue till the next date.
Yes. Because it is fixed for necessary order,
It's okay.
not execute.
Money has been paid, deposited in the court, Your Lordship.
That is one part.
Salary also, draft salary also. Anyway.
We can
everything will
decide
be
on
decided in
that.
the final hearing.
Decide it then and there we'll decide it.
Yes.
Obliged.
Lordship, in this matter, praying for amendment of the memorandum of second appeal, my lord.
IA for
Praying for, my lord, amendment of memorandum of second appeal, my lord.
memo of second.
Yes, my lord.
Okay. You have any objection? Amendment?
Lordship, regarding amendment, Lordship, they should have to file a substitution petition, Lordship. Because in the IA, Lordship, sorry, in the main
What
case,
kind of amendment?
My lord, page 5, my lord. Begum Nurjahan Mazhar, where she was a defendant number
Okay.
5 in title.
Yes, yes.
Lordship,
You have to file a substitution petition.
Lordship, or to there, to
After
there,
we know,
Yes, my lord.
you'll have to file a substitution petition. We'll list it for another day.
because she was not a party in the titles. In the original suit, she was a party, but in the RSL, they have not implemented her.
Oh, then I think you'll have to file 2 petitions.
Lordship, First of all, they should have to file a petition for impleading her as a
Party and then for
Lordship.
substitution.
since she has died lordship, they should have to also file an IAL lordship for impleading them as
Yes,
a.
yes. We'll list
Well,
it for another date.
Unknowingly, but they were not met parties, my lord. Well,
You'll have to, as it is, you'll have to file a petition. List this matter on after vacation.
There is nothing lordship mentioned in the petition lordship when she died. Why they have not
Yes.
impleted lordship, no
It's in the
such
paragraph.
pleadings is there lordship.
You'll have to give everything in details. List this matter on, you want a date or after vacation?
my lord, any date may be fixed, my lord.
22nd October. List this matter on 22nd October.
Item 24.
May I please, Your Honor? My lord, in IA number 453, I am applicant, my lord. I have filed application under Order 22, Rule 10A, my lord. Respondent number 1 has died, my lord.
I think they won't have any objection.
My
But
lord?
they are not here, no?
Yes, my lord. My lord, kindly see last order, my lord.
Last time you were not present.
I am present, my lord. But, my lord, the order is passed in I number sense, my lord.
This present is IA number 453.
453, my lord, under Order 22, Rule 10A.
Hmm.
I am applicant in this IA. And the rest, my lord, I am opposite party and respondent.
Let them come, we'll decide all the matters together.
Yes, my lord.
Today or some other day.
Others day?
They are not represented today.
Yes, my lord.
The applicant, you are a respondent, no?
I am respondent.
Appellant, গোটেইকেইটাতে একে ক্লাব কৰি লিখি দিলে হৈ যাব. The applicant is not represented today. Learned counsel Mr.
M. Hussain.
M. Hussain is present for the respondents. গোটেইখিনি ক্লাব কৰি লিখি দিবা. List this matter of surviving IA কেইটা লিখিবা দেই, dispose হোৱা IA কেইটা লিখিবা. After 1 week.
Item 35.
My lord, IS 6044 substitution. Substitution. Appellant number was
604, okay.
yes. Appellant number 1 expired. In loss of kindly see paragraph 3, my 3 and 4. 4, paragraph 4. Those are the legal representative of the appellant number 1. And appellant number is 1, 2, and 3 already on record. So now the present applicants may be substituted. Present applicant, my lord, pays 1 cost title, 1 subgenasa.
This application was filed within period of limited.
Yes, yes, one within period of limit.
When?
It is filed on 25/9/2024.
No. Reported on 13 February 2025.
Yes, my lord. It is filed on 25/9/2024. And there is some mistake. Then it has been corrected and again listed. So applicants, the present applicants, they will be substituted. Only the other 2, 3, page 7, my lord. 1, 2, and 3, they are already on record. Page 7.
There are two dates here.
my lord.
Two dates. One date was showing 26 September 2024 and one date is showing 13 February. There were some defects earlier.
Defects. We are corrected. Expired on 24/8/2024.
Duty is over. Third learned counsel Mr. J. Ahmed for the applicant. Who has filed his application under Order 22, Rule 3 of the CPC for substituting the legal representatives of the appellant number 1, Subjan Nessa.
Yes, Subjan Desa and page 1 item. Subjan Desa to 1 to 13. As appellant number 1 to 113.
In the Subjan Nessa Third learned counsel Mr. M. Hussain.
M. Hussain.
For the respondents to stop the heard both sides, it is submitted that the application was filed within the period of limitation to stop thereby prior to substitute the legal heirs of Subjan Nessa is allowed. The legal heirs of Subjan Nessa may be legal heirs, the following legal heirs, yet heritage.
Page 1.
Page 1 to 2, page 1 to
3.
I'll treat us. The following legal heirs of Subjan Nessa may be substituted and implemented as array
As respondent
the array
1
of parties in the area of respondents in the connected RSA number 64/2001
as appellant number 1 to 113.
as appellants number 1 to 113. In terms of the above observation, this application stands disposed of. The appellants to file
Corrected costed line.
applicant to file corrected amended cost item.
Hello.
No, it is disposable.
My lord, I have 4021. I have filed for injunction, my lord.
Okay.
In this, I am, my lord, necessary to substitute the newly substitution.
In RSA and the IAL KDA. In RSA, in the collected RSA and the connected IA 4021 to stroke 2024.
In IA, they will be corrected now.
Yes, yes.
Sometime may be granted to substitution the legal heirs of the appellant number 1.
Parties to Lydia, applicant no, parties to file amended cost item. This will include everybody of 2 weeks.
I will submit my cost title in RSA and he will do.
Most of them.
May please your lordship, my lord, this application is for substitution of legal heir of respondent number 4, my lord. This is matter is listed for the first time, my lord. Notice may go to the.
Yes, well, notice may go because, my lord, what happened in this case, my lord, I received a copy of the IA under impression that I appear for respondent number 4. But when I checked out the record today, my lord, I'm appearing for respondent number 3 only
Okay,
in the connected RSM.
okay.
So let notice
right.
go, my lord.
In the IA, no?
Yes.
Okay, all right. Then your appearance won't be shown here?
No.
Okay. Learned Counsel, Mr.
SK Chakraborty.
S.K. Chakraborty is present for the appellants. Applicants. Issue notice to the respondents returnable within 4 weeks.
Item 27.
Lordship, respondent number 2 has expired. As such, we have filed a substitution petition. However, in filing the substitution petition, there has been a delay of 687 days. So along with substitution, we have filed one setting aside abatement and condonation of delay.
Lokoram, on that of Lokoram.
No, Lordship, respondent number 2 is Kameswari Das, Lordship.
Here the petitions are only for death of Lokoram.
The legal heirs of Lokoram has been already substituted, Lordship. IA number 108.
1084, yes.
84 is for substituting respondent number 2.
Actually, in the subject matter, it was written as Lokoram. On death of Lokoram, alias Lokeswar Dasis.
Lordship, his appellant number 1. They have been substituted.
But here it's written in the matter of on death of Lokoram Das. Let me see the prayer then. Oh, yes, yes. Commissary Das.
Kameswari Das, Lordship, respondent number 2.
As it was written under the, in the last line of the paragraph. So here, everywhere it is mentioned in the cover file on that of Lokoram.
Yes, sir.
We'll take up which petition first?
Delay condemnation. Delay condemnation, Lordship.
Which one number?
1080.
1080.
Yes, Lordship.
Learned Counsel, Mr.
A Singh, Lordship.
A. Singh is present for the applicant who has filed his application with prayer for condonation of delay of how many days? 680 days, 87 days
87
in
days.
preparing the substitution application for deceased respondent number 2, i.e. Kameswari Das, who died on 10/1/2023, leaving behind her son, Sri Bhupen Das, as her legal heir and successor. Who so heard, Mr.
NM Datta.
NM Dr. Learned Counsel for the respondents.
1.
Respondent number 1.
1.
What about the other respondent 3?
Lordship, respondent 1 and 2 have filed wakalatnama. In the wakalatnama, they have entered appearance.
No, you have to issue notice. This is delay condonation. You have to issue notice to all the respondents. Learned Counsel, Mr.
NM Datta.
NM Dr. is present for respondent number 1.
1.
Issue notice to respondent number 3. How many respondents do you have?
Respondent 1 and 2, Lordship.
Only 1 and 2.
1 and 2.
Then here number 3 is also given. Nipendas. How many respondents you have in the RSA?
In application. Only 1 and 2. Nipendas is, Your Honor, appellant number 3.
Let me check the RSA file. Okay, all right. Issue notice nalage. You for the
Appellant.
appellant. Then here, why you have shown appellant as respondent number 3 in this application?
Application option.
Nipendas has passed away.
Yes, Lordship. His legal years have been substituted.
Already substituted.
Already substituted.
What is the reason of the delay? Where have you mentioned the reason of the delay?
Para number 3, Lordship. Of para number 3 of IA number 1083, Lordship. Only 1083, Lordship, IA number. In para
No,
number
but I am
3.
taking up the IA number 1080. You will have to mention in the IA number 1080 about the cause of delay.
In para number 3, Lordship.
You have any objection? This submitted that the applicant was not aware
Not aware, Lordship.
not aware of the death of the respondent number 2, which resulted in the delay. The learned counsel for respondent number 1 has raised no objection. It appears that there was no mala fide or laches on the part of the petitioner or applicant. Subvenient grounds have also been shown, thereby delay is condoned. In preferring the substitution application of respondent number 2. What about abatement?
1083, Lordship. IA number 1083.
Do you have any objection? To लिखिए attend के लिख ले हम third learned counsel Mr. N Singh no?
A Singh Lordship.
K
A.
Singh for the petitioner learned counsel Mr.
NM Datta.
NM Datta for the respondent number 1. As the delay of 687 days in preferring the application for substitution of the legal heirs has been condoned, comma, the abatement of the respondent number 2 is hereby set aside. Parallel, no objection has been raised by the respondent number 1. In terms of the above observation, this application stands disposed of. At Mr. N. K. Singh.
A Singh Lordship. On behalf of R.K. Bhuyan.
It was IA number 1084. On behalf of the applicant and learned counsel, Mr.
NM Datta.
NM Datta for the respondent number 1, full stop. The application for substitution of the legal heirs of respondent number 2 Commissary Das is hereby allowed. No objection ta likhi diwa. And the legal heir Sri Bhupen Das, no?
Bhupen Das.
Only one.
Only one. Sir.
And the legal heir Sri Bhupen Das is allowed to be substituted and added as respondent number 2A.
2A.
In terms of the above observation, this application stands disposed of. The respondent, the applicant to file an amended cost title. Anything else?
No.
Number 38.
Madam, am I appearing at respondent number 2 and 3?
2 and 3.
2 and 3.
May please Lordship, on the last occasion, we have taken steps as per the direction, Lordship.
Respondent number 1.
No, Lordship. Lordship, office note dated 7/8/2025 says that no served report and unserved notices have been received till date. In respect of performer respondent number 4, 5A, 5B, and 5C.
Okay. I think one respondent has passed away, I think. Learned counsel Miss
B. Ronghang P.
B. Das.
Ronghang P.
B. Ronghang P. is present for the applicant. Learned counsel Mr. DCC Pupam is present for the respondent number 2 and 3. Service reports on respondent number 4, 5A, 5B, and 5C are awaited. Office note dated 7/8/2025 indicates that unserved notices have been received or received back. Unserved notices have been received back relating to respondent number 1 and 5D. And the postal endorsement reflects as addressee deceased.
Okay.
Look.
List after puja vacation.
Item 29. IA 1225 is an injunction petition, Your Lordship. In a second appeal, I am the respondent in the second appeal. The title suit was for declaration of right title interest. It was filed by me. I was the plaintiff in the
Injunction?
injunction. The title
What
suit,
kind of injunction?
Lordship,
Injunction.
during the pendency of the second appeal, they may be restrained from selling, cutting the trees in the suit land and selling of the trees.
You are, all are present for the respondents, for all the respondents.
I am for the appellant, my lord. In the IA, I am opposite. Let my lord.
Lordship, the title suit was 20/2011. It was filed by me against the defendants, and the title suit was decreed in my favor in the year 2014. Thereafter, they preferred an
You
appeal.
are originally the plaintiff or
Plaintiff.
defendant?
I'm
Plaintiff.
plaintiff. I prayed for declaration of right title interest and recovery of possession from there, because they are in possession over a plot of land measuring 7 bighas. And Lordship, the suit was decreed in my favor by judgment and decree dated 23/12/2014
Concurrent judgments in your favor.
in my favor.
So now the appellant is before us.
Yes, Your Lord. The appellant filed the second appeal, and during this pendency of the second appeal, I have annexed an FIR, Your Lordship, wherein I have approached the police because they have cut down many bamboo trees and sold it on the market. That FIR was registered as a non-FIR case because it is a civil dispute, Your Lordship, primarily. The police will not interfere. Non-FIR case number 105/24, and the report was submitted. That is why I am aggrieved, Your Lordship. Even after filing this, Your Lordship, I have been instructed that they are continuing, small amount of bamboo bushes are being cleared and sold in the market. They have filed their objection, Your Lordship, and they have stated that they have not been selling these bamboo bushes. Though they have not denied, they have admitted in paragraph 12 that they have cut some amount of bamboos, but they have stated that these bamboos were cut for personal purposes as well as for funeral of the neighbors, for making pandals or the funeral rites of the neighbors. Be that as it may, Your Lordship, the fact of cutting down the bamboo trees is not disputed. And in my petition, injunction petition, I have listed the number of trees, Your Lordship, in paragraph number 8. There are many valuable trees as well as many bamboo bushes, Your Lordship. Concurrent finding in my favor during the pendency of the second appeal, if they cut down the trees, I'll be at loss, Your Lordship. That is why, Your Lordship, during the pendency of the second appeal.
Yeah, please, my lord. First of all, Lordship, kindly peruse the application, my lord. But in the application, my lord, they have annexed the copy of a order of this honorable court, my lord. And unfortunately, that was a defective. It is listed.
Lordship, to that aspect, I'll just commit one thing just before it.
My lord.
Why I have annexed it? That is for showing the conduct of the parties, Your Lordship. As I
It cannot be a conduct, my lord. It is the failure of the council. It is the defect. It is not a conduct, my lord. That is why my learned friend should not make a being an officer of this court, my lord. I should not.
Any aspersion against my learned friend. Just the dates, Your Lordship. The title suit was decreed on 23/12/2014. Thereafter, the title appeal was decreed on 25/8/2017, Your Lordship. So in 2017, August 2017, there is a title appeal which is decreed in my favor. Thereafter, they have filed, the client have filed the second appeal. His client has filed the second appeal within time, Your Lordship, not with delay. However, Your Lordship, as per the order annexure 1, at page 12, Your Lordship, it is seen in 2017, they have filed the appeal. In 2018, 27/2018, almost 1 year, 11 months from date of filing, the matter was defective. The client perhaps did not inquire it from my learned friend, Your Lordship. It was defective. 3 months time was given to remove the defect. I am not casting any aspersion on the advocate, but the client ought to have been diligent, Your Lordship. 3 months time was given, the defect was not removed, Your Lordship. It was dismissed. Thereafter, they have prayed for recalling this. In 2019, it was recalled. And the second appeal got listed and admitted in 2019. The appellate court judgment and decree was of 2017. 2 years, with no allegation on the advocate. The client ought to have been diligent for these 2 years. It was not admitted. He ought to have been taken care and taken consent. 2 years, it was lying defect. And after 2 years, it was 2019 appeal was registered. And then it was admitted. Just to show the conduct. Otherwise, the possession is with them. concurrent finding is in my favor. There are bamboo trees and other trees as well, Your Lordship. There is an allegation that they are cutting down the bamboo trees and selling in the market, which they are denying that they are not selling, but they have not denied that they are not cutting. Under such circumstances, I am simply praying for an injunction. During the pendency of the second appeal, they may be prevented from cutting down the trees and shrubs in the suit land, Your Lordship. That much.
May I please, Your Lordship? My lord, this whatever my land friends submitted, my lord, annexing, my lord, nowadays online system is there, man. Annexing this order of 2019, my lord, because of the fault of the council, my lord, effective or not recoverable. That's why this honorable court allow and according law. Subsequently, in the year 2000, my lord, it is admitted. Records were called for, fixed for hearing, and IA, it was both the court below judgment was set aside. And there is no sense annexing this order, my lord. Well, had there been my learned fate continuously, all the order annex of this honorable court, it would be a different matter. Purportedly annexed this because just showing that it was dismissed because of defective. Subsequently, what happened that defective was, if your lordship kindly see the annexer 1 of this IA, my lord, well, it is, I have made a statement, it is my fault, man. It is the fault of the counsel of the applicant, IA at that time, my lord. It is my fault. I had no knowledge of listing. Nevertheless, subsequently, this honorable court allow. I have been asked to rectify that defect, and that was allowed. Appeal was admitted for final hearing on 6th of January 2020. Then it was fixed for final hearing by virtue of the your lordship kindly see the both the court below order state and fixed for final hearing in the month of May 2022. Order white order 23rd May 2022. Now, because of the usual course, may ought to have been come. Now, in the meantime, this application is filed. Now, I take your lordship the para 4(6) of this application. But at the same time, your lordship kindly appreciate.
Para 4(6),
my lord, sorry. 6 of this, my friend, the applicant's application.
Application. Or appeal.
No, application. This IA.
Okay.
That after the admission of the second appeal, your lordship got it.
Yes.
Para 6.
Yes. Yes.
After the admission of this appeal, the opposite party started to intimidate the petitioner by various means. What intimate, I do not know, my lord. The opposite parties also started to cut down various trees, which were planted long back by the petitioner's husband and sold the woods in market. My lord, just after the admission of the appeal, that means in the year 2000. 5 and, if you count here, my lord, more than 5.5 years. He ought to have come earlier, first of all, my lord. Just after admission of this appeal, my lord. Appeal was admitted on 6th of January 2020. Now, kindly see the next paragraph, the contradiction. Opposite party stated that recently in December 2024, opposite party have sold a bamboo bush which was presented on the suit land to a third party for rupees 40,000, and the said third party have already taken away the bamboo trees from the suit land. The opposite party had lodged and written complaint before the officer in charge Panbari police station, which was registered as such a non-affair case. Then give the listed of the trees, my lord. Now, my lord, we have made an objection in this our application to this, my lord. My lord, so far the cutting of bamboos, only cutting of bamboos is concerned, my lord. We have fairly submitted, my lord. Some pieces of bamboo was cut down. My lord, since I have been possessing since more than 2 decades, it is our land. We have planted this, all this list of trees and bamboo. Nevertheless, since it is a continuous proceeding, both the courts below have stated, my lord, we are obliged by this honorable court, my lord, we have to respect the order of the honorable court, my lord. Some pieces of bamboo cut down, we are fairly admitted, my lord. Because of our neighbors died, my lord, for the purpose of funeral ceremony and for making pandals of Holy Shraddha. My lord, prima facie, the applicant have to satisfy that basic allegation in the month of December, I have cut down bamboos and sell it to the market third party. Who is that third party? where is this money received? Merely making an omnibus statement, my lord, will not make it the prima facie case. And what is the irreparable loss? My lord, cutting of some piece of bamboo to help a pauper, all the those who have the my lord, poor people for funeral ceremony, as well as my lord, the making pandals, my lord. It is admitted, my lord. We have making fair submission. So therefore, there is prima facie, there is no, my lord. My lord, so far, my lord, I fairly submit. Applicants, the opposite party and the applicant will not cut down any further tree. If your lordship, we have no objection that. But making an allegation, well, your lordship, the affair, the findings during investigation, Jamabundi is taken for every witnesses. It is known that the Jamabundi of the witnesses is that first party and second party in the city of the same village, also neighbors. Well, we are cousin, in fact, own cousin. Both the parties had a dispute over respect of suite of land, and both of them are claiming should land to their own. At any moment, there may be a severe riot between the parties of the suite land. That is why it ended in the final report. So far, the cutting of the bamboos, only bamboos is kind of selling it. Absolutely false. Yes, fairly admit, cut down because of this religious two purpose. So prima facie, your lordship, so many judgment is there, canon of judgment, 2010 year, referring, at the same time, prima facie, satisfy this court that.
No, why should you contest? As agreed by both the sides, you won't cut down trees, then we'll dispose it off. You are saying that you won't cut down. Yes. You have agreed that you have cut down for funeral purpose. Yes. Okay, then as agreed by both the sides, we'll maintain the status quo. Until further orders.
Status quo. Status. No problem.
Okay.
Yes. Till the disposal of this.
Yes. So come back and pass the order after the break. It will be maybe 2-3 paragraphs. You can leave the court. You can leave the court. I'll come back and pass the order in the court itself. Till
The head of the neighbor.
is agreed by both the sides, maintain status quo to the suit plan.
As on today.
As on today, till the disposal of the appeal. There's another IA, you'll place a submission on that IA later, or?
It is the only IA, your lordship.
Only IA.
Silo?
175,900, that is filed by me, my lord. It was disposed of.
Disposed of.
My lord. That is the stay order of the impugned judgment.
Oh. Okay.
It will dispose of one and
So, if you agree, then we can dispose it off. It was listed, I don't know.
Oh, my lord, real, my lord, sorry.
I don't have a copy of that.
Well, it can be disposed, yes.
It
My
will
lord.
be stayed subject to that status quo.
Yes. I'll pass an order after the break.
My lord. Hello.
Yes. Haji, Learned Counsel for the applicant, Sri Rampoti Kori, who has filed this application. He is the applicant, no? Rampoti Kori?
Yes. No, Rampoti Kori is the appellant.
No, Rampoti Kori, no.
Applicant is my lord.
Rajkumar
Rajkumar
Kori.
Kori.
Learned Counsel for the applicant, Sri Rajkumar Kori, stroke respondent, who has filed this application under Order 39, Rule 1 and 2 of the Code of Civil Procedure, within bracket CPC for short, bracket close, for an order of temporary injunction restraining the opposite parties from destroying, cutting, selling, etc., any of the trees, crops, plants, over the suit land, standing over the suit land till disposal of the RSA number 108/2019 full stop. The opposite parties in this case are the appellants of the RSA number 108/2019. It is submitted that the suit land relating to the title suit mentioned in the
20/2020.
Hmm?
20/2011.
title suit 20/2011
11.
Described, which is the suit land here, schedule A, B, or C in the petition?
Petition, it is not mentioned.
Not mentioned.
My lord. Not any.
Relating to the
it is-
title suit likhi diya ho jabo.
My lord.
20/2003, no?
No, 11.
2011 has been decreed in favor of the applicant who stopped. It is contended that the respondents have removed certain bamboo trees and sold the same for a value of rupees 40,000 to a third party, full stop. This has been vehemently denied by the respondents, full stop. To their objection, the respondents stroke opposite parties, respondents no, opposite parties opposite parties stroke appellants have however admitted that they have
No, fairly submitted.
Huh?
Fairly submit, my lord.
No, fairly submitted, have fairly submitted that they have indeed removed some bamboo trees for funeral rites of a neighbor, full stop, as as they were in possession of the suit land. I have considered the submissions at the bar with circumspection. The respondents, the appellants, stroke opposite parties have submitted that they will not
Cut down any trees.
cut down any trees or any
Bamboos.
bamboo standing on the suit property, full stop, as it has been agreed by the opposite parties, that they will not cut down any trees, standing trees or crops, trees only, no?
Trees only,
or
because
trees,
crop is a continuum.
as mentioned in paragraph
Seven.
described in paragraph 8, no?
7, my lord.
As described in paragraph 7 of the petition, 8 of the petition,
My lord, I think
more,
there
more,
are 7 and 8.
8 only.
My lord.
Nalage as the following trees likhi diya, as described in para 8 of the petition, para 8 of the Goskidal naam likha ase, page 6, Heir to page 6. After considering the submissions at the bar and as agreed by both the sides, full stop, this petition is disposed of with an order to maintain status quo over the suit property as on today.
My lord.
Okay, they will not maintain
Certainly.
status quo. In terms of the above observation, this application stands disposed of. We'll register the appeal.
Already.
No, we will fix the date for the appeal hearing.
It is already in the due course, my lord.
Okay.
It is already.
Anything else? No,
No.
other interlocutory matter?
No, my lord. No.
Okay.
That can be disposed of, yes,
Oh, acha.
by suspending both the.
Eto dispose nokoriলে হ'ব, তাৰ লগতে dispose হৈ যাব, main suitটোৰ লগত.
Well, let's so but the trees mentioned in para 8, my lord, that may be mentioned.
Yes.
That may be
Particularly
mentioned.
those trees.
My lord, my lord.
You'll maintain the status
My
quo
lord,
for
that is-
electing
yes,
those trees.
yes. It will be.
No more status quo to be maintained apart from those trees.
No.
What else status code could be better?
All right. As on today, we'll pass an order.
And cutting of these trees, my lord, no problem.
Yes.
Highly.
Agreed, likhi diya. appeal to be listed in due course
Due course, it is already there.
in the usual process. In due course as per usual process.
Item 40.
May it please your lordship, lordship on 7/7/2025, the party has taken the brief from our chamber lordship. So our name is struck off from the first brief.
No, no, no. No, you will file an application. You will file an application. Huh? Then we will pass an order and then they will be represented.
Lordship.
Lordship, there are two IAS, Lordship, that copy of the IAS have not been served to us.
Lordship,
They are withdrawing, trying to withdraw.
Lordships.
Okay. You file an application.
Lordship.
List this matter after 2 weeks.
2 weeks.
File.
Yes, lordship.
Item 41.
May I please, your lordship, this application is for early hearing of the second appeal.
Okay,
Yes, my lord.
we'll pass an order.
My lord, just it maybe fixed in the month of November, my lord. My lord,
Okay,
already we
month
have
of November.
November, my lord.
Learned Council Miss IA 2400, no?
Yes.
Yes.
Learned Council Miss
SS Bora.
SS Bora is present for the applicant. Learned Council Mr.
T Sheikh, my lord.
T Sheikh is
Yes.
present for the for the opposite parties. This application is filed with a prayer for early hearing of the RSA number 161 of
Yes.
2019.
Yes.
Therefore, this application is allowed and the RSA number 161 2019 is listed for hearing on.
In the month of November, my lord.
In terms of the above observation, this application stands disposed of. RSA लिखी दिया, both parties are presented, list this matter for early hearing on 4 November.
My lord. My lord.
Item 42.
Chief,
Yes,
Um,
yes.
for the appellants. Applicants have filed 2 petitions. Applicant number 2, original defendant, she died. So while substituting the names, there is a delay. There is no delay within, then setting aside abatement petition has been filed within time. So that 2 petitions may be allowed.
Will allow.
No, my lord, we do have a, actually,
No, there are other applications also that I'll come to the other.
no, actually, they have only served us the condemnation application.
No.
There should have been 2 applications. And my lord will come to the title page, my lord. An application under Section 5 of the Limitation Act 1963, IA number 4082 of 2024.
I have not come.
Read with to a 3-year filed by the applicant number 2 and 3. There is delay of 796 days, my lord. It is not that there is no delay, 796 days.
I have not come.
It's filing an appropriate application under Rule 21 for substitution and setting aside. Now here, separate applications for substitution and setting aside abatement will have to be filed. And against that, condonation petition has to be filed. And now they have only served us this condonation petition, my lord.
Lordship, let me come. He has not come to the correct pictures. By the time application IA 4082 has been pending, limitation petition was pending, applicant number 2 died. Therefore, we have filed separate application for substitution as well as setting aside abatement. These 2 petitions is before this honorable court now, which has been numbered as 2773, 27773. That means there are 2 applications. The moment these 2 applications is disposed of, then 4082, 4080 will come. There is limitation petition come. So let us dispose of this petition.
No, they have to be served, my lord. We have not
Please, you have not come to the correct place. Please sit down.
We have not received copies, my lord. And my private party also, he has also not received. My lord will hear him out.
Okay, you give to a copy each.
No, these 2 applications within time. Let copies I'll serve.
for the other application. There are 3 more
No,
applications.
whatever, my lord, we have not received any copy. So any question
It
of
was-
going ahead.
it-
Sir, copy.
Copies is not
After that, the
supplied.
case may be
Lordship,
taken up.
Copies is,
You find within time, but copies have to be. furnished.
copies, lordship, copies have, if copies is not supplied, then it will not be listed. Copies is already served, I have the copy to show the.
No,
that
we have
has
not
been
received,
checked.
my lord.
There are 3 respondents, they have not received the copy.
Lordship, if it is not supplied, then it will not be listed before the honorable court,
Correct,
then
but-
there will be defects.
Correct, I know, there will be defects, but.
All right, I will submit
Why
it.
they
What
turn
they
up
wanted,
always?
let us come, what they wanted, they have not understood that, because I myself, I am not able to understand the matter, there are 5 applications now.
No, I understood. But I understood. Only these 2 applications have to be disposed of.
First, these 2
I have
applications,
understood.
then there are 3 applications will come
That will come later.
later.
Mm.
So these 2 applications, for these 2
But you
applications,
have to give them
no,
copies.
if these 2 applications, there is no delay, these 2 applications without giving notice, it can be disposed of by
It
the
can be
honorable court.
disposed of, but there.
Because there is a provision, I have filed a petition within time.
Yes, yes.
90 days and 60
Can
days,
be
that can be
disposed
disposed of. The moment they
But
see
the
it,
arrears parties, give them copies, we will hear it.
I don't know if there is anything to be heard on this point.
Nothing to be heard.
And it is only thing that
will
I
be
have,
allowed-
she
it
died,
will
I have
be
given
allowed.
explanation on so and so, I have filed it applications. All right, in that case, let the matter be fixed on.
It will be
Friday.
allowed, there's nothing to
I'll
be
sort
heard.
the copy right now to them.
Okay,
I'll sort
when do you want me to fix?
any day, lordship, because if it is only the law delays because of this problem. It is not, there is nothing to be
9
delayed.
September? 9 September?
yes.
Yes. Please serve the copies, furnish the copies. Let's just matter on 9 September.
My lord, this appeal has already been admitted, my lord.
Mm.
It was admitted on 5/2/2025. But since execution case is going on, my lord,
Mm.
that is why I filed application for stay. At the time of admission, they have given assurance, but the execution proceeding is going on. So I have to file application for stay. So it may be stayed. An
Okay.
early date of hearing may be given. I have
Kindly
to-
see the order dated 13/2/2025.
13
In,
years.
in my lord, RSA 183/2024.
Yes, that
My
it
lord.
has been admitted.
Man, here it is observed that taking into the account of the short question involved, this matter is again on fixed on 25/2020. That on that day it was not my lord,
Listed.
listed. It was not listed. In the meantime, my lord, execution proceeding has started. It is correct. But may I pray that already this short question involved, even the record was not called for. Can it be, my lord, next day of the execution is on 28/10/2025?
Hmm.
And before that, any date may be fixed for final hearing.
My
This is the
lord,
court,
after vacation, my lord,
Yes,
and
yes,
in
can
the
be fixed for
meantime,
final
yes.
hearing.
finally, my on
And record is also necessary, my lord.
the court.
Record has not been called for. Ultimately,
called
in
for-
second appeal, my lord, record is required, my
No,
lord.
record is necessary.
Record is
yes.
necessary.
Record was
Even
not-
if it is not necessary for the court also,
Hmm.
it may necessary for us also.
Yes, yes.
Any date, my lord, before 28.
Yes, yes, sure, sure.
My lord, in the meantime, my lord, execution, my lord. Otherwise,
Next date
this
is
exercise will
28/10.
be carried on.
I'll give you my word, let the records come and let the fix for hearing,
Right.
let us fix for final hearing in case.
In case of.
In
yes.
case it doesn't come, records won't come,
Then stay maybe.
we'll
I know,
dispose
my-
the
I-
petition. I'll
My
dispose
lord,
it. I'll pass an order to that effect.
my only submission, my lord,
Hmm.
let the date may be fixed till then, till that day.
Same thing on 20.
Execution maybe till that day.
Till then, my lord, nothing will happen because next date is
Because
28/10.
suppose
October.
writ has been issued. For the purpose of writ, next date is fixed on 28/10. But in the meantime, if writ is executed, nothing will survive in this case, my lord.
One petition.
And writ, for the purpose of execution of the writ, date is not required because it is
Yeah,
on
you can
report.
go within that time, you'll have to
Within
go
that
and
time.
execute, okay.
One application has been filed from their side, and on that date, my lord, there is a-
We have not filed a name.
Okay, just a moment.
Fine.
If you are prepared, then we will hear the IA, and if not, then we will fix another date.
my lord, next week then, my lord.
Next
In IA, I am.
So in the meantime, my lord, otherwise if tomorrow is writ is executed, then this case will become impact.
I assured my lord from till next date, my lord,
My
no
lord,
execution.
At
Next.
least till next date, my lord, let the
Then we will hear it today only.
Let the
In
execution
IA,
be
my lord,
pending.
it may fix in the next week. Until then, no execution will be.
Okay,
That, wait.
okay. I'll pass an order in the
No, no, my
Yes.
lord.
I'll stay then.
Yes,
Till then.
till then, no
Or
problem.
it may fix for final hearing also, my lord, on that day. I'm ready.
For final hearing?
No, I have no objection for final hearing or for IA also, but till then I may be protected.
My lord,
This is
can it
only
be
my
like
prayer.
that? Can it be like that? In the month of October, it may fix for final hearing. Until then, executions may be. Okay.
Yes. No,
Okay, heard Mr. SK Ghosh, no?
yes,
SK Ghosh for the applicant and learned counsel. Mr. Heard learned counsel Agoto Hiva, learned counsel Mr. SK Ghosh for the applicant and learned counsel Mr. PK
And home,
N Hock
my,
for the respondent.
my,
You have the Karanama
yes. I had keep-
Yes.
keep-
Yes.
for the opposite parties. For the opposite parties, this application is filed under order 41 rule 5 read with section 151 of the code of civil procedure within bracket CPC for short, full stop.
prayer page 6.
With prayer to stay the judgment and decree, execution of the judgment and decree dated 29/6/2024 passed by the learned additional district judge Hailakandi in TA number 4/2023. This appeal or the title suit?
Appeal.
Which one has to be stayed?
Appeal, because suit was dismissed.
Okay.
It was reversed. And title execution case number also I have mentioned, 11 of 2020.
It's not required. Reversing, dismissing the.
No, allowing the appeal while reversing the.
Allowing the appeal against the TS preferred by the appellant against TS 61/2000. Post of it is submitted that a title execution proceeding being EX number 11/2025 has been drawn up and this suit may be and writ has been issued. Full stop. The applicant is apprehending that he may be dispossessed. Okay.
Yes.
Dispossessed from his property, and so he has prayed for stay of the execution proceeding being TX number 11/2025. So I'll stay only that much, title execution.
Yes, yes, title execution may be stayed.
Or execution of the judgment and decree.
Yes, yes,
Same thing.
Considering the submissions at the bar and after hearing both the sides, till the next date of listing, the execution of TX number 11/2025 arising out of judgment and decree dated 29/6/2024 in TA number 4/2023 is hereby stayed till the next date.
Date.
Till the next date of listing, full stop. To RSA to list this matter for hearing on 23rd October.
23rd.
Meanwhile, call for the original records of title appeal number
Title suit as well as.
4/2023 and original trial court records of TS 61/2020 from the respective courts.
For final disposal.
Hmm?
On final disposal on.
I to thako to
Actually,
নালাগে।
same I. 2I5.
Much.
Oblex.
Item 24.
May I please, my lord, this application is filed for my lord, correction of a my lord typographical mistake of one date, my lord. Kindly turn to page 8, my lord, order, my lord.
Which one?
Page 8, my lord.
Page 8.
My lord,
But
here, my lord.
Counsel, Mr.
S.S. Shikhar, my lord. My lord,
Eight, no.
date should be my lord 29/8/24, but here it has been mentioned as 16/2/2023. And in my lord main CRP, my lord, page 16. Date is there of the judgment, my lord.
Surya, I think you should notice. You should
Madam.
notice. You should notice.
My lord, only some date, my lord.
I understand, you should notice. I will pass an order, I will allow it. You should notice.
But my lord, then my lord, learned court below, my lord, will proceed, my lord. That is fine.
Please read the application, entire
My lord.
application.
My application, my lord.
Mm.
Here, my lord. I am reading, my lord, from page.
No, you read
Two,
the
my-
entire application.
Page two, from page
It's
two.
a
my-
short application. Read
page,
it.
from page two, my lord.
Mm.
That the applicant preferred the instance civil division petition IO under section 115, read with section 151 of the Code of Civil Procedure 1908, challenging the legality and uh, propriety of the order dated 4/7/25 passed in Miss J case number 10/25 by the learned additional district judge Borpeta. By the said order, the learned court kept the application under order so and so seeking stay execution of the judgment and decree dated 29/8/24 passed in money suite number 10/2019. That is the date, my lord, 29/8/24. And in abeyance pending this admission of the appeal, that this honorable court by an order dated 18/7/25 was pleased to issue notice upon the respondent and was further pleased to stay the execution of the judgment and decree dated 16/2/23. This date, my lord, passed in money suite number 10/19. So, my lord, money suite number is same, my lord, but 29/8/24 should be there, my lord. A copy of the order dated 18/7/25 is annexed, my lord. That after obtaining the certified copy of the order dated 18/7/25 passed in CRP so and so, the applicant found some typographical errors in the said order, which are reproduced below. In paragraph 7 of the order dated 18/7/25, it was written as considering all aspects, the exhibition of the judgment and decree dated 16/2/23 of
Exhibition?
my lord, here, my lord, it has been written as exhibition, my lord. That is one.
B das kun. বনজিৎ নেকি?
It should be execution, my lord. Yeah, that's my lord. Money suite number same, my lord, but date only.
Oh, maybe das. From where he got this date?
My lord, page
In
16.
prayer also it is not given. I don't know how this date
Page
was.
16, my lord. Only page 16, my lord, of the main CRP.
Why this date was typed, I don't know. Neither it is mentioned wrongly in the prayer,
My lord.
nor anywhere.
I have annexed the money appeal, my lord. In that, my lord, appeal, my lord, here is my lord title judgment, my lord. Kindly page 16.
বিপ্লবপুর ক'ৰ পৰা এইবোৰ ডেট পালে বিচাৰি বিচাৰি ক'তোৱে নাই এইকেইটা ডেট Okay, your name?
S.A. Sikdar.
Huh?
S.A. Sikdar.
Lahar Learner Counsel for the applicant, Mr. S.A. Sikdar. First of the applicant has filed his application with prayer for correction of the typographical errors which has crept in the order dated 18/7/2025 passed by this court in CRP IO 267/2025. It is submitted on behalf of the applicant that the date of money suit 10 of 2019 has been wrongly typed as 16/2/2023, which may be typed as, which may be corrected and typed as
29/8/24.
29/8/2024.
24.
Considering the submissions, the application is allowed this application is allowed to correct the sentence or to correct the date of money suit, date of judgment and degree of money suit 10 of 2019 as 29/8
Money suit 10/2019.
2019 as 29/8/2024 instead of 16/2/2023.
My lord.
Exhibition, let it remain.
My lord.
We have not prayed for correction of that sentence, let it remain.
That is the. It will
This
be
order will
under-
also, this will form a part of the order dated.
Order dated, my lord,
18/17 in CRP 2267 of 2025.
My lord.
You have annexed the money suit in the CRP, no?
Yes, my lord.
Let me see the date,
My lord, page 16.
page 16.
Yes, judgment, my lord.
Nowhere it is mentioned, see from where, I don't know,
Page 16.
where the date has crept up.
Page 16. Actually, my lord, there is two judgment, my lord. So this is subsequent, my lord.
All right.
My lord, my lord.
In
Hello,
terms of the above observation, this application stands disposed of.
my lord. Hello.
Item 45.
May please be me.
Mm.
Lord, the condonation of delay petition, first time lordship, 93 days delay, so notice may kindly be issued.
Okay. Applicant to take steps to issue notice to the opposite parties, returnable within 4 weeks, list accordingly.
Item 49.
তিনটা বছর কিবা এটা আছে না হিয়ারিং ওটা উঠি দিম মই তিনটা বছর
This is lordship, actually for withdrawal of the amount deposited by the insurance company, 40 lakhs, 1,010 rupees, lordship.
he has no objection.
The
So for
only objection is that because I have challenged the dispute of the accident. Otherwise, my appeal is infactual.
Okay.
They submit the fund is the inimitable of like amount. Like amount,
What?
inimitable.
Okay, bond will be executed. Learned Counsel Mr. S.R.
By
Agarwal.
A.R. Agarwal,
A.R. Agarwal is present for the applicant.
by respondent claimant number 1, lordship.
There is a 8 number of respondents.
All are
One is the
sons
mother.
and daughters.
Applicant, only the applicant will take it.
Applicant 1.
Oh, applicant number, okay, applicant
They are
number.
sons and daughters.
8 numbers.
Oh,
They are major sons and daughters, lordship.
okay, okay. Applicant,
Applicant 1, lordship.
full stop. This application is filed with prayer for withdrawal of the 50% of the,
That 40,000 amount may kindly be mentioned, 40 lakhs. That is
50%
with
of,
interest. Though.
this is the 50% or the entire
My
amount?
lord, actually order was passed for 50% out of 60 lakhs. So that is not, we have already deposited, but it is not mentioned in the record. Rest is not mentioned, but he has find out.
With interest is deposited also.
I don't know, but he has seen that 41 lakhs is deposited.
They will calculate, registry will calculate the
Yes,
interest.
yes.
I'm not
Whatever
going to
maybe
calculate.
amount is deposited.
50% of the awarded compensation deposited by the insurer before the registry of this court. Learned Counsel Mr.
Arsipal.
Arsipal is present for the insurer.
My lord.
Full stop. After considering the submissions at the bar, the applicant number 1, Srimati
Srimati Surabhi
Das.
Sophie Das is allowed to withdraw the 50% of the awarded compensation from the registry of this court on her executing a bond for proper verification
Of
and
like amount.
identification by the registry of this court.
Bond of like amount.
50% of the amount
Bond
may
of-
kindly be mentioned also.
Bond of
40
like
lakhs.
amount. Bond of like
50%
amount.
amounting.
No. Why should I take the pains? The registry will do the calculation. আর কি বলে?
That is required, lordship.
Much obliged.
40 lakhs.
If it is whatever, the 40 lakhs, almost 40 lakhs.
Lordship, 40 lakhs with interest,
No,
50% along with interest, Lordship.
50% of the.
If my lord, it may be given,
Interest will always be given by the registry. If not, then you come to me.
No, Lordship,
I'll
let another petition will file if there is a interest.
Interest will be given. If not, you come to me.
No, Lordship, if the.
I'll convince the registry. Don't worry.
May I please?
Mm.
Lordship, I have taken a step today, Lordship.
Today you have taken
Yes,
steps.
Respondent number 1, Lord.
Service report on respondent number
1, Lord.
1 is submitted. List the matter on after 2 weeks. Parties are represented. Service report on respondent number 1 is submitted.
Item number 3 for admission.
Hmm. What about this side?
3 o'clock here should be, I think.
Oh, then we will come at 3 o'clock then.
Okay, well, because
I'll come
otherwise
at 3 o'clock. That is why they are not here.
this will not be correct.
Yes, yes. Yes. Okay.
We came to the lordship list is over. That's why we came. Madam.
Okay. Okay.
The suit, my lord. Tenant versus landlord were 2 issues, my lord. One is bona fide and second is a defaulter, my lord.
Hmm.
Now, page number 101,
CRP?
CRP, ma'am. Para 11 and 12, ma'am. The plaintiff 101.
Hmm. Yes.
Miss, para 11, my lord.
Hmm.
The plaintiff has taken the plea of bona fide requirement
Hmm.
of the suit premises. Corroborating his plea, PW1 said in his evidence that plaintiff number 4, along with plaintiff number 1 and 2 are intending to run a tea selling business and also for storing a stock of tea. Further, he states that suit premises is only place of business for them and they have no other source of income at this stage, and therefore the suit premise is very much necessary for them for livelihood. During cross-examination of PW1 said that at Sarupatar area, they have only one property, that is the suit property. It was pleaded by the defendant that plaintiffs are preparing to sell the suit property and plaintiffs has no other bona fide requirement of the suit premises, but defendant side has not adduced any substantial evidence to establishing that pleading. Your lordship see that there is a 2 kata of land and there is a room 20 by 20 room. So this 4, they have given executed a power of attorney also, which in fact they have annexed all the documents, but that power of attorney has not exhibited. That power of attorney show there is no power of attorney is given for the establishing exhibit 2, that is the shop premises. The power of attorney which I copy.
Power of attorney for establishing?
That this suit premises is used for
For
sale. There is no other to
For-
run
for
the
sale.
shop. To run the shop, only sale. That is their exhibit matter, but they have not. Page 3 may be seen, my lord.
Hmm.
This power of attorney is para 2.
Hmm.
To enter into agreement for the purpose of disposal of the land fully described in schedule below with any parties for and on behalf of us with any terms and conditions as our attorney thinks fit. Number 3, to receive consideration of the land from any purchasers and to acknowledgement the receipt thereof. Then para 9, to negotiate the sale transfer, to execute the sale agreement and to execute registered sale deed in favor of the purchaser and delivery the physical possession.
Hmm.
So then schedule is there in page number 4, that a plot of land measuring 2 kata.
Hmm.
So
So my question is that anyway, my lord, whatever is, may have a case, I may not have a case, but these records are necessary. The lordship may decide this issue. Maybe within 15 days also, lordship may call for the records and decide this issue. Without these exhibits, well, no, the records will come and then I would have to establish my case that this was not for a bona fide purpose, and then there was a legal notice also before that, my lord. The legal notice does not also. This is also exhibited, my lord, but there is no appreciation of these documents, my lord, by the trial court, my lord. Your lordship, see, before that I read the default, my lord.
You are saying that this legal notice was not submitted.
No, you exhibited, but this was not appreciated, my lord. The page number 103 may be seen, my lord. Same, my lord, judgment, page number 103.
And this power of attorney?
This is exhibit 2. And legal notice is? Exhibit 4, my lord. Now, before I reading the exhibit, my lord, I just take your lordship to para 13, page 103, my lord.
Yes.
May I read, my lord, para 13? Yes. For convenience as well as to arrive to a fruitful conclusion, these two issues are discussed together. While addressing issue number 5, it comes to the notice of the court that among his reliefs, the plaintiff asks for recovery of future rent of Rs 3,500 per month with effect from the month of April 2022 till the eviction of the defendant from the suit premises. Hence, in my opinion, due to typographical error, Rs 1,100 was inserted instead of Rs 3,500. Hence, the rate of rent amount as sought by the plaintiff shall read as 3,500 for this purpose. But before deciding the issue, we ought to determine the amount rent which is yet to be paid from the month of April 2019 till the month of March 2022, that is the month which the suit was instituted by the plaintiff. Now, if your lordship see the legal notice, which is issued on 7/1/2021, that is their document, there is no whisper that he has area rent is there, my lord. 2000 from 19, that area rent is due. This has been stated to be in the plain, but in the notice which was issued in 2021, there is no area rent, my lord. So therefore, my lord, my submission is that, my lord, lordship will call for the records, my lord, as I'm entitled, my right will be prejudiced, my lord, and let it decide after 15 days. I have no objection, my lord. That is all. These documents were not been placed, my lord. And that is their exhibits, my lord. They filed the bulky objection.
Yes.
My lord, first of all, the suit was instituted for the purpose of eviction of the tenant. Here there are 4 plaintiffs in the plaint, but the tenant and landlord relationship is between the defendant as well as respondent number 4, only 4. And it is an admitted fact during the cross-examination that respondent number 4 is the landlord and defendant is his tenant, and he has been paying rent to the respondent number 4 only. So as per the Assam Urban Area Rent Control Act, there is a relationship between landlord and tenant. So as regards the title of the land is immaterial in this regard, my lord. And this is very well decided by the trial court below in page number 96 of their petition, whether the suit is maintainable or not. Lordship upon paragraph number 6, page number 97. Lordship had found.
This is the made CRP, no?
CRP.
Yeah.
You are asking for disposal for hearing.
For stay, my lord. Till
For stay and hearing.
Yes, yes.
But
Stay
we
in
have
here.
objection because, my lord, as per the trial court judgment is concerned, we were directed to return the salami amount, Rs 2,37,000, that we have returned via bank transfer. And I have annexed the bank statement in my objection also, Then the learned trial court also directed to pay the future rent of rupees 2,500 per month, and the present petitioner, that is a defendant, is paying rupees 2,440 rupees. Again, in that case, he is a defaulter. Now, my question arises here, my lord, is whether a defaulter is entitled to any benefit under section 115, where there is no provision for second appeal under the act. Because when there is, law provides that when there is no provision for second appeal, the scope of 115 revision petition becomes limited, my lord. So at present state, he was defaulter or not, that is the issue which was already decided by the learned court as well as appellate court, and there is concurrent finding of both the courts below. Now at this stage, present stage, after the disposal of appeal, first appeal, when there is no provision for second appeal and they have approached by way of section 115 CPC here, and then the scope becomes limited, my lord. So now my humble submission is that whether he is entitled to whether this petition is maintainable when at the present stage he is a defaulter because he is not paying the rent as that was directed by the trial court and that was upheld by the appellate court. So I have annexed page number is.
That we have challenged in my lord. And secondly, ma'am, this legal
Page
notice
number-
will make it clear.
I am not
Lordship, please
allowed
see
to
that-
submit, my lord. I have not yet finished, so I may be allowed, at least I may be allowed. Court may pass any appropriate order, I may be allowed to submit. Annexure number 12 of my objection, page number 320.
Page number?
320.
You are showing me paragraph.
No, I am showing my written objection. Paragraph 6
Of the judgment?
of the judgment, where they have disputed the power of attorney. The whether the suit is maintainable, issue number 2. So defendant side has categorically stated in his pleading that the suit is bad for non-joinder of necessary party. It is stated that one of the shareholder of the suit property is not implicated in this suit, hence the same is not maintainable. On thorough perusal, it appears that plaintiff number 4 has filed this suit on behalf of plaintiff number 1, 2, and 3 by power of attorney exhibit 2 and exhibit 3. Defendant raised the plea that once Bindra Devi, who is also a signatory of the power of attorney, has not been made party in respect of the suit. Record reveals that the same Bindra Devi has also executed exhibit number 2, but the plaintiffs are seeking relief, my lord. The plaintiffs are seeking relief under Assam Urban Areas Rent Control Act 1972, wherein the question of title is not a paramount issue. So who is the owner of the land, how much land they have, it is not an issue under the Assam Rent Control Act. Here the issue is plaintiff has slightly pointed out in the argument that in an ejectment suit regulated by the Assam Urban Areas Rent Control Act 1972, the title to the property is immaterial. What is material is whether there exists any relationship of landlord and tenant. The same observation has also been reiterated by the Honorable High Court in Kalyani Devi versus Usha Rani and others. It is section 2C of the Act has widened the scope of the word landlord. Hence, the plea of the defense is not tenable in such circumstances. Apart from that, there was no specific plea regarding maintainability. Accordingly, this issue is decided in favor of the plaintiff. Now, my humble submission is that they are pleading that the power of attorney was given for the purpose of sale, not for that plea has not raised before the trial court. Now, when the scope of civil revision under 115 is limited, they are coming with a new plea that this is not maintainable because the power was given for the purpose of sale. That document was exhibited during the course of the trial by the plaintiff. Nothing was concealed during the course of the trial. And at that time, they have not taken the such plea. Now, my lord, they have come up.
Which plea?
That the power of attorney was given only for the purpose of sale. That plea was not taken during the course of the trial. So when petitioner has approached under section 115 CPC, where there is a very limited scope, then they are coming with a new plea, my lord. Now they have said that legal notice was issued and subsequent to the legal issue, they have filed the title suit. No, my lord, after 1 year, 3 months, after completion of 1 year, 3 months, we have instituted the suit. And after receiving of the legal notice for vacation for bona fide requirement, whatever the notice has already served,
After 8 months of the receiving notice, the present petitioner, that is the defendant, has replied that I will not vacate the suit premises because the salami amount is due, and because you have not returned the salami amount, I will not vacate the suit premises. And then thereafter we have instituted the suit, and during the cross-examination, what suggestion was put that you have pleaded and you have taken the defense that I have not vacated suit premises because the salami was not returned to me. Now, my lord, when suggestion was put to him that we are ready to, and we have also pleaded in our plaint that we are ready to return the salami amount, but instead when we are ready to return the salami amount, are you willing to vacate? He said no. Are you intending to purchase? Yes, I have intention to purchase. Now, my lord, in the cross-examination, I have annexed all the materials, my lord, all the copies of cross-examination, judgments, appeals, memos, title suit, everything in my objection. Now, my lord, my question, my submission, respectful submission is that when he has admitted that he has 2 commercial premises at the radius of 500 meters away from the suit premises, he had 2 other business established. These all are admitted facts in the cross-examination. But he is not willing to vacate. Why? Because he is interested in the suit premises. He wanted to purchase, but the landlord is not intending to sell. My lord, he cannot compel and force the landlord to sell him the property. Otherwise, I am keep fighting. Now, my lord, there is 800 square feet commercial premises, total commercial premises. That is Schedule A of the land. Now, Schedule B is 400 premises. Now, every tenant has vacated by way of oral communication. Only 2 tenants, that is the DW1 and DW2, who are refusing to vacate the suit premises. The present petitioner is owing place 400 square feet out of the 800 square feet of the total commercial area, and another tenant is owing 150. My lord, total, if my lord makes an addition, it becomes 350 square feet. Now, out of the total 800 square feet, 350 are already occupied. So, how will I start my commercial business or any business establishment there only in 150 square feet or 200 square feet? Because we are 3 brothers. We are jointly willing to start. Now, and they are saying that 1 kattha land, 1 kattha land, 2 kattha land, my lord, that is residential premises. I have already mentioned in the plan, that is at page number 140 of my objection. Every ground of the civil revision petition is, my lord, decided by the trial court as well as the appellate court, and there are concurrent findings. So now they are coming up with new grounds, my lord, then that is not admissible, maintainable. Paragraph annexure number
140.
160.
In the IA?
No, 160 of my objection.
Okay. Objection was filed in this only. I cannot find the objection actually. 106.
Their copy of the plaint has been. And now, my lord, no case. I have returned the salami amount. And there is also area. That
Page number 100?
160 of my objection.
Yes. Running page about 900. 160. You have to mind. Objection. We do not have the objection, surprisingly.
We have filed day after yesterday only.
Yeah, only you got it yesterday.
Day after yesterday.
Yes. And Lordship may see even their objection, page 324 may be seen by that.
No, we do not have the objection.
Oh.
We'll fix a date. As Partner?
Partner?
We'll fix a date. I do not have the objection.
Till that they do not proceed with the execution.
Already
Only that is
trial court has waited for the judgment of this court, so they have not passed any orders.
Yeah,
So
we
if
don't-
tomorrow they
Short date, short date.
short date, my lord, short date.
I don't have any objection, madam. Short date also, I don't have any objection. Only thing is that tomorrow is the execution court, trial court is specifically passed the order that High Court is with the season with the matter, so I'm not passing any order. So lordship, they will not execute, that's all.
That also, my lord, without stay such order has been passed, that also our interest has been violated. So he has.
Once we find out there,
No, as per.
in fact, my lord, the records will be important, the exhibits.
See, as it is, I am aware of this case, so it won't take me much time to.
Yes,
dispose it
very
off.
correct.
So next week,
Next week?
all of Khali data that video.
Only, lordship, only till then, they will not proceed, matter. I mean,
They won't proceed, they won't proceed.
but court has to pass an order that.
Not
No,
required.
Not required, my lord. We will not, because I have the order. The court is waiting for the order of this honorable court. So
Not
tomorrow
required actually.
they may file a petition and we will be filing that we have returned the security amount.
10 September. It will record on Anjiboli Dibode. On a more direct so.
Direction may be used.
Yes, yes, I'll pass on order. It will feed my to reverse.
Lordship will pass that, no coercive steps will be taken by them. Otherwise, my lord.
No. I will hear it out. I'm sorry. I'll hear it out.
But
I'll
then,
hear it out. A very short date I have fixed.
but execution case is tomorrow, my lord.
Huh?
That is the problem.
They won't execute. They won't execute.
But if they proceed, my lord, then 2 ways, my lord.
No, nothing will happen. There will be a reversal order if you have a genuine
As per
case.
the instruction received, the petitioner is shifting his business also as per the instruction received, but not officially, madam, but as per the instruction knowledge, just for information.
I'm sorry to say, I'm really not convinced to pass any order now.
I understand, I don't say, but at least not with some observation, my lord, this will help me to inform to the trial court. Some information. I'm not saying that.
I'm sorry, but I'm actually, after hearing halfway through, I'm really not convinced to pass any order. I'm sorry.
Lordship, then.
I do not have any predetermined mind.
Then lordship
but
make it part of my lord, part of.
I'll keep it as part heard, yes. And learned senior counsel, Mr. J. Roy, for the applicant, and learned counsel, Miss
P. Mishra.
P. Mishra for the respondent. Oh, this is a revision petitioner, petitioner for the petitioner applicant, for the petitioner, and Miss P. Mishra for the respondent. List this, the objection filed by the respondent is not on record. Ready to bring the objection on record. List this matter on 10 September as part of matter.
The records are important, I think, anyway.
List this matter on 10 September.
Yes, sir.
Maybe not part heard.
No, part heard matter.
Okay.
Huh?
Maybe not part heard. You see, he
10
is,
September.
he is more intelligent. He can read my mind. Because I said I'm not convinced. At this stage, I'm not
Okay.
convinced.
Let it, 10 September.